we have a quorum, we have 5 people. And let's start with the minutes. I assume everybody has reviewed them. Is there any discussion? Does someone want to make a motion to accept them?
I'll move to approve the minutes.
Votes? Okay, unanimous.
Well, I wasn't here, so I just read them. So.
Right, that's what I said, okay. Administrative update. Is this it?
Okay, so the major things that have been happening on the administrative front are that we're in the final stages of new website development. As you recall, you approved some funds to enhance the commission's website to make it so that the forms that people use are more accessible, that we have an easier way of communicating with the public, and most importantly, of updating our own website, because right now, everything goes through Sam Houston State University. So we've gone through, I think now, 3 different students who work at SAM who have our commission as their sort of area of responsibility, but they are also doing all sorts of other things. So if that student is on break or something, then we have no way of updating the site. So Lee is constantly sending urgent, update our site web, emails. And what this will allow us to do is have a 24-hour company there whose entire job it is to support us. And it will allow Lee to do some updating on her own, which is great. They've showed us a bit of a sample of what they're thinking, and it looks really nice and clean. So we're hoping that by the next meeting, we'll be able to project it so you all can see a new site. They're going to show us a mock-up type thing within the next, I would say, 3 weeks. But we're going to try to add some enhanced functions that allow people to do a lot of things through the site, like searching for complaints by discipline or by laboratory, or are those the 2?
By last name.
By last name of the complainant. So that way people can really take a look at the body of the commission's work over time. So that's happening. We also have outsourced our IT function, as you recall. To be honest, it's a little rocky. We've had our email go down a couple of times. I have a call-in to the president of the company to talk to him about my concerns. I don't know if it's because we're small that we don't get a call back for 2 hours or what, but when our email goes down, it becomes really hard to function. And I don't think that 2 hours or more than 2 hours is an appropriate amount of time for them to respond. So we're struggling with it a little bit, but we're hoping that once we make contact with some people, that will work itself out. We released the annual report as we're required to do under our new statute. I'm sure you all saw it here in your materials. It basically just updates the prior year's report. It's in the same format, and it complies with the statute, which sets forth all of the items that we have to include in the annual report. The budget is something that we're going to discuss, I think, throughout the course of this meeting, because we do have quite a bit of funds that we need to spend by the end of the fiscal year, and there are some projects in the works that we would like you all to consider and possibly vote to allocate some funding toward. So if you have any specific questions about the budget, I'm happy to answer them, but perhaps one way to go about it would just be to talk about each project within the context of the budget as we move forward. So I think that's it on admin. Do you have anything else? Oh, an important thing that I wanted to mention. The Office of Capital Writs is our neighbor in our building, and they came over to us kind of desperate because they have 2 new attorneys, and they have no space to put those attorneys, and the Facilities Commission has no space to put those attorneys. So what they asked is, we have a small front area with a reception desk that Lee and I aren't using right now, and they asked if they could borrow that space until the Facilities Commission is able to find them some new space, and so we thought, being good neighbors, that that would be something we could do. The only way it really impacts us is that Lee and I are accustomed to shouting across to each other, so we'll have to find a more efficient or less noisy way of communicating, but otherwise, I don't think it will impact our operations. And we met the folks and they seem very nice. The person who'll be sitting there is a paralegal, and the DIR, which is the State Information Technology System, is going to come over and make sure that she can get on their network and so forth. DPS will give her a key card so she can get in. We can lock our doors to make sure that, you know, the information we have is kept confidential, or any confidential information we have, we can lock up. We have the ability to do that in our cabinets and so forth. Things that are sensitive, like our procurement card, we can secure all of that. So I feel pretty good about sharing that space, unless you all have any objections to that.
No.
As long as you can secure the information. That's certainly
Okay.
Do you, I think everyone is aware, they have not been the new appointments.
No, we do not have new appointments. I contacted the governor's office about that, and they said they're still working on it. They've gotten a list from Texas A&M, which I think might have been the last list of names they were waiting on, and they didn't expect to have the appointments announced by today, but I do think they expect to have them by the next quarterly meeting. I know they're working on it. It's probably a bit more of a process than we understand on our end, you know, vetting the folks on the list and so forth. So hopefully we'll hear something pretty soon.
So, are they expecting to change those whose appointments ended on 2013?
I'm not sure what's, you know, they obviously have the ability to do whatever they want with those
Right.
seats, so they will do whatever they think is appropriate. I do know that there are 2 commissioners who asked to roll off, and those folks, they are looking at the new names for those seats, so I know they're vetting them. My understanding was that they weren't intending to replace anyone else. They were going to keep folks on, but I don't know if that has changed, and of course, that is an internal process that goes on at the governor's office. But I imagine they'll probably keep most everybody on who expressed a desire to continue to serve. And those who want to roll off, hopefully will be given amnesty and allowed to go on with their other professional and personal obligations.
I think we're done with that. Okay. I guess we should go on to the complaint screening section.
Okay.
Okay.
That's section 3.
Right, the first bit of information here is just a revised complaint form. And if you see here, this is our new letterhead. You remember how we told you we were going to make the letterhead look a little bit more professional? Well, this is what it looks like, except that the gold is a seal, you know, and it's a really professionally done letterhead. So that you know, that's our new, what we'll be using from now on in correspondence. The idea with revising this complaint was to make it a little bit easier. I can tell you that since then, Lee and I have been going back and forth with the woman who helped us with this form to revise it even further. Do you have a sample of the new copies? So she'll send those around so you can look at them. The idea just being, we wanted you to know that we're trying our best to make these forms as professional looking as we can, to make them online fillable forms, and that's sort of a work in progress. You had already approved the content of these using our old letterhead and our old format. So this is more of just an FYI. If folks have questions about the forms or concerns about them, you're welcome to let us know. We'll make changes.
Now, this will be on the computer.
Yes, yeah.
And it will be expandable because the spaces are relatively
Right.
small.
Right,
Okay.
so when you fill it out, we'll work with the IT provider to make sure there's enough space for people to write an explanation and to include an attachment if they need to, like a Word attachment. They should be able to include, because we ask them to provide supporting material, they should be able to attach any documents they need and so forth. Anything else on that, Lee, that, no?
And the most recent copy also has changes. There's a few edits and mistakes. And if you guys find any others, let us
Typos,
know. But
yeah,
most of
we've
them
made-
I've already pointed out.
Mhm. And we had somebody work with us to do this to make sure that it works in hard copy and online, and that people are able to fill out the form in the easiest possible way, which for most people will be online, but not for everybody, because a lot of our complainants are inmates, and I don't think they have access to online fillable forms. I could be wrong, but I don't think so. So Lee has to send hard copies of these out fairly frequently. So we have to have them work in both formats.
So how do they get access to them if they don't have, I mean, is there a stack of these at the prisons and stuff that they can request if they don't have internet access?
No, typically what they do is they write Lee and say, literally any communication we get from anyone, she sends them a form.
Okay.
So usually there's some outreach from them to us. I don't think we can look into it, but I don't know that the prison system allows for like a stack of forms. Does anybody, Nick, you know?
That's a good question. The innocence questionnaires are in the inmate handbook, the offender handbook. So that might be something worth looking into, is getting in place like some information in the offender handbook.
I mean, it might just save because it just seems like that's a waste of communication for them to have to send a letter to us and we have to send the material back to them. If it's just simply a matter of asking for the paperwork so they can submit a form, it just,
Yeah, I didn't realize there was such a handbook, but we can certainly, I'm sure it's quite a bureaucratic process to get something put in the handbook, but we can try.
The only other thing is if it was separate sheets, I would think is it would be put on some shelf and they would forget where it was. And, you know, if it's in the handbook, it would be better, but if it's just papers, I mean, you know, probably wouldn't be requested that frequently and,
Usually they seek us out, but, you know, I know they have libraries and things like that.
That's
Maybe
what I was
that's a
thinking,
place.
that
yeah,
would
the
just be-
library would be the
Yeah.
best bet.
because their complaint about the handbook would be, I'm sure we're talking about adding an additional 3 to 4 pages. That's copy
Costs money,
costs, that's binding costs, but just, that's what I thought. I just assumed that in the library you could ask for the forms.
Well, we will try it and see what response we get. We'll
That's a good
update.
idea.
The next thing we'll talk about is, if you recall, we had this Expertox complaint that was sort of hanging over from the last meeting. Do you want to talk about that, Richard, or do you want me to?
You can go ahead, we've all heard of that, just if you just go summarize.
Okay, so we had a complainant who was convicted of possession of a controlled substance back in January of 2009. And his defense lawyer sent a request to a private laboratory that's accredited here in Texas called Expertox. They asked Expertox for independent testing of the sample that he was being accused of having violated the law for being in possession of, which is probably not a very articulate way of saying it, but you know what I'm saying. What happened is that they tested the substance and it came back with the same result that the lab that the prosecutor used. that it was a controlled substance. What Mr. Starkey complained about is the fact that Expertox was not accredited to perform controlled substance testing under the DPS rules. Now, it wouldn't have changed the outcome of the testing, but it raised a whole question before the commission about to what extent do laboratories need to be clear to the public about what they're accredited to do and not do. If you recall, they have accreditation to perform toxicology testing by the College of American Pathologists. DPS had written them a couple different letters being very clear that that was the limit of their accreditation, that they were not accredited to perform controlled substance testing. DPS, what we talked about was that DPS, because they administer the accreditation program here in Texas, would do some follow-up work with the laboratory, which Pat Johnson did. And their explanation was essentially that, number one, the analyst who did the testing is no longer with the laboratory. And number two, that they weren't aware that this was a criminal case, that they thought they were testing the sample for vitamins. They didn't really know what the purpose of the testing was. Frankly, the invoice that's in the materials that we received makes it pretty clear that the analyst picked up the evidence from the sheriff's office, and I'm not really sure why you would pick up evidence from the sheriff's office if it wasn't a criminal matter. But regardless, where we are now is that DPS, I think, has pretty much exhausted their inquiry with the laboratory. So I think the discussion now needs to be with DPS about, to what extent should we be encouraging laboratories on their websites, if they're in the private setting, to be clear with the public about what they're accredited and not accredited to do. I looked on their website, and I think because they say, we provide all these different services, but there's no asterisk or anything like that. A lot of people would assume that, I think that they were accredited, if they didn't understand the nuance of Texas law. I talked to the defense attorney who requested the testing. She said she never would have requested it from that laboratory if she had known that they were not accredited, because if it had become an issue in the trial, she couldn't have used the results, and she very rarely gets funding from the courts to be able to support independent testing, and she probably rightfully would have been reamed by the judge for not having figured out that they were not accredited for that discipline. So that's sort of where we stand. Pat's here. I don't know if you have anything else you want to add.
Well, just that we asked them to provide us a list of any and all cases like this where they tested actual controlled substances on a criminal case for the last 2 years. Dr. Lakissa sent us back a very lengthy list of every request they had to test an actual drug sample. But there were none of them on a criminal investigation. They were either tests that they do for a hospital, or they were actually toxicology tests on a blood or urine sample. So he complied with our request to provide those records, and I forwarded all those to Lynn, I believe. And then with the explanations that Lynn reported on the case of 4 years ago, the complaint that you received was something that happened about 4 years ago, probably 5 years ago now. So anyway, Dr. Lakissa complied with our request, and we're satisfied that they're not, what they did 4 years ago or now 5 years ago, they're not doing now.
I have a question.
Yes.
Hasn't it always been the case that anyone who wants to can go to DPS's website and see a list of the accredited laboratories?
Yes.
And that option was available then?
Yes.
Because I find it a little disingenuous, the defense attorney said she wasn't aware of whether they were accredited. I do it all the time, on my side of it. I'll check. If they ask that evidence that we've used to be released, I always ask them, who's going to do the testing? And for that very reason, I just want to make sure it's going to an accredited lab, so we don't get into a whole, well, you know, they have a different result, maybe there's some exculpatory stuff here, but the law says the lab result doesn't come in. So I'll check that. So there's no reason then that the defense attorney could not have just checked the website and seen the list of
That's correct, and I
laboratories.
believe when Lynn talked to her, her statement was that she didn't know that Expertox was not accredited in controlled substance testing until she received some communication from the DA's office, Harris
Correct.
County DA's office.
Okay. But she never spoke to why she didn't just check the website to see what their accreditation was.
I didn't,
No, she said she wasn't aware until the Harris County DA's office sent around a list of the accreditation status of the laboratories in the different disciplines. And then she became aware of this issue and understood that Expertox was not accredited in that discipline and decided, obviously, they weren't going to use Expertox anymore. I mean, there's an obvious issue with the defense counsel here, but I think we see that in a lot of these cases.
Okay.
I don't know, Bobby, what your experience has been. Do you think most people think to look for accreditation status? They do.
Yeah.
So, I think the discussion really needs to be about, I don't think the commission has any further role in this particular complaint, but in terms of the advertising of accreditation to the public, should we work with DPS to try to make sure that laboratories are clear about what their status is, what disciplines are accredited or not, or do you want to just leave it alone?
My feeling is I just leave it alone. I mean, you know, it's false advertising, it's, you know, so.
There really isn't any solution unless the legislature
Well-
decided they had to have a disclaimer saying we are not certified to do forensic
Yeah.
testing in criminal cases, like, you know, like lawyers have to say they're not board certified in a particular area.
In the
But that-
smallest print as possible.
Right, so that, I don't see that there's much more we can do.
No.
And they could complain to the accrediting agency that accredited them, saying that they said they're accredited, they did the testing, but clearly they're not. But there's not an agency really other than DPS that, like the Texas State Board for physicians, if you're doing some false advertising, you can go to them and they actually have some
Right.
punch to it. But I don't know that there's I don't really.
But actually, they didn't do any false advertising, they just didn't correct a false,
You know, their response is a little problematic.
right, but I mean, technically, they didn't do false advertisement. They just
They
didn't
did the
correct.
testing and they
Right, didn't
respond.
correct the false impression. So,
Do we need to move to
I don't think,
drop this, or?
it would be a dismissal.
yeah.
Is there anything else you want to say? I mean, I know that DPS, where they see these issues, tries to work with the lab to make sure that there is no false impression about what their accreditation covers.
yeah, if you look at their website, they say, and I mean, you kind of have to look at the fine print. If you look in the fine print, it does say that they're accredited only in toxicology by DPS. But you do have to kind of, I mean, their website is 4 or 5 pages long, and they break out the categories of testing that they do. For a solid dosage drug, they have that in a group of, gosh, I can't remember exactly what they call it, but it's in a separate category from their toxicology testing. When you get down to the toxicology testing, they do say they're accredited by DPS, so their website is, I could see where it might be a little confusing to just the average Joe Blow on the street. So we can go and ask them to maybe clarify that a little bit. In the section where they talk about unknown substances, which is the category of testing that they would put, solid dosage drug testing in, we could ask them to put a statement in there, we are not accredited by DPS to do drug testing on criminal cases or something. We could ask them to do that.
So my question is, I mean, we don't know how many of these companies do something like that. Is there anything that you could think of to enhance what you put on your website to make that clear, the distinction?
No, on our website, you know, we state, Expertox is accredited in toxicology testing only. We do that, you know, for every lab that we accredit. It's the scope of their
Right.
accreditation is posted on our website. So beyond that, I don't really know what else we can put on our website. I mean, I'm open for suggestions, but I don't know what that would be.
I mean, the only other thing I can think of is just making a general statement, not for any one particular company, just in general, the differences between toxicology and controlled substance and, but
We can't do anything. I mean, honestly, we can't do anything. It's just so, I think that if DPS is satisfied, then I think we should just dismiss this.
I'll so move.
second.
Aye? Aye. Unanimous.
Okay, the next complaint is, complainant Iran J. Hawkins was convicted of 2 counts of delivery of cocaine and subsequently sentenced to 15 years in prison. He alleges that the GPS regional lab in Garland misreported controlled substance testing results that were used to convict him in this trial. Basically, his assertion is that Kay Davis, who was the original analyst, had examined the case, and then she retired before testimony was given. And another analyst, Chris Youngkin, retested the case, and he alleges that that yielded a different result. And that essentially if copies of the original report had been obtained, it would show that there were 2 different results. Then he alleges general chain of custody issues and mishandling of the evidence by both examiners. You know, in terms of jurisdiction, obviously the commission has jurisdiction. It's controlled substances. It's November of 2008. What we did was we asked DPS and Garland to submit the essentially a copy of the case file to the commission so that we could look at it. I don't know if any commissioners have had a chance to look at it. Dr. Kerrigan's not here today. She's our toxicology expert. Not that this is tox, not to be confused between tox and controlled substances, but I think she would probably know how to read these better than anyone. I don't know. What do you think, Dr. Eisenberg? Should we hold off until she has a chance to look at them?
I
Or-
certainly haven't had a chance to do it, so that would be my recommendation.
Okay.
We can table this until the next meeting if you'd like.
Yes.
I think that's best. Want to make a motion to it? Or-
I'll move.
Second.
Table it.
Aye?
Aye.
Unanimous.
Okay, the next case, let me know if you want to take over at any point.
Well, this one has the most words that I don't know how to pronounce, so I'm comfortable with you
Okay.
continuing if you like. 'Cause
Okay.
I'm never gonna get through this polymerase, whatever.
So this is a case that we've heard already involving a defendant, Mr. Gustavo Mireles, and he was convicted of first-degree murder back in August of 2002 and sentenced to life without parole. He alleges that the analyst who conducted the DNA testing at DPS lab in McAllen, using something called the PCR method, that testing provided inaccurate results. Basically, what he says is that the examiner did not identify a sufficient number of matching loci regions. And he asserts that if STR technology had been used to retest the DNA samples, there would not be a positive match against his DNA. If you recall, what we looked at last time was whether or not in the PCR testing there were sufficient loci to match according to the standards of that type of testing. And Dr. Eisenberg, you're welcome to take over at any time, but the conclusion was that in 3 or 4 of the DNA tests that were done, or in 3 or 4 of the pieces of evidence that were collected, there was a 9 loci match, which is basically the full range of loci matching under the PCR methodology. Now, there have been some questions raised since then about whether PCR is sufficient, but I don't think those questions have gone to the level of basically striking that entire
So,
type of testing.
I was not at the last meeting, but when I looked over the material provided by the DPS, there was nothing that I could see that was done incorrectly or inappropriately. In every piece of evidence, there's always an attempt to try and get as many genetic markers as possible. Back when this testing was done, they used a kit, I believe it was Profiler, that looks at 9 STR loci plus the amylogenin marker. There keeps making reference to the original core 13 loci. Again, you could look at as many markers as you want. The FBI is now considering upping that to 22 or 24 markers. The fact of the matter is, in any sample, any evidentiary sample, there's no guarantee that you'll get results at any or all markers. And so in this particular case, all of the evidentiary STR markers that yielded an interpretable result apparently were consistent with this case, and they could not exclude Mr. Morales. And again, I haven't looked at the data in many months now, but there was nothing inappropriately done. Now, there's always the possibility that additional testing could be done. The technologies have improved since early 2000s when this case was originally done. But there was nothing inconsistent from the DTS result from what I can recall, and that's what is written here, that would suggest that they did anything wrong. Now, certainly, I think the option is always available to try and ask for retesting, but I don't see that that's something that the commission, this is something that his attorney, and I know that they've been in close contact with the Innocence Project of Texas, and I think that's what we encouraged. But as far as anything that the commission can do, first of all, it occurred before the statute was in effect, so I think our hands are tied. And as you see that, I'm not sure that anything has changed. I don't think we have jurisdiction, and the fact that we made recommendations to certainly to Mr. Morales to contact the Innocence Project of Texas, I think, and I'll certainly, we agreed that any of us would try and help him and the Innocence Project as possible, but there was nothing that we have gotten that substantiates the claim. The fact that they didn't do 13 markers, I mean, it basically just goes to a statistic, the weight of the evidence.
Yeah,
Whether
well,
you get-
yeah, I'm sorry.
No, whether you got 3, 4, 5, it's still, there's a match and you can calculate a statistic. There was nothing that certainly excluded the genetic results as being incorrect.
Well, if you remember with this case, the Innocence Project was here at the time, and they made direct contact with
Yes.
the family, and they are apparently not bothered by the DNA. They think that they have a good case for him, but the impression that I get from the Innocence Project is that they really can live with the DNA results.
Yeah, I think part of the
And-
confusion is that at the trial, there was a lot of discussion about one result that came back with only 2 or 3 matching loci. And because of that, I think there's an impression that that's all they got, and that's not what the report says. There are 3 or 4 different samples where the entire range of loci were matched, so all 9.
That was my recollection. And again, it's just whether it's 9, 13, 15, or 17, it's, basically looking at 1 in a billion versus 1 in a trillion, quadrillion, quintillion, sextillion. These numbers at some point are meaningless. You cannot exclude the evidence as matching a particular individual.
And Nick Vilbus is here. I know that they've been in touch with the family, and you can get, DPS, if they get a court order to do retesting, will do it. So it's a legal issue at this point.
Yeah, right now, we're still in the process of rebuilding not only the file, but the entire picture of the case. There's a lot of evidence and information in there besides the DNA that doesn't necessarily add up. So it's not that we're not bothered by the DNA, it's just how does that fit into the overall picture, because there's a ton of evidence and information that is strange to say the least. So, but for us in a case like that, it takes a long time to go back and rebuild the entire picture of what went on, how the investigation was played out at the point in time, and that's what we're trying to do right now.
So from the commission's perspective.
We can just close this.
Now, we did dismiss it. They came back to us in the interim, both Mr. Morellis and his sister, asking for reconsideration. I brought this in front of you because I think it's important that you all see when a complainant asks for reconsideration, but I don't think it requires further action unless you all wanted to reopen it. But if you don't, then I think we just keep moving.
I think we should let the Innocence Project proceed, and then we could always reopen it, or they could request more testing, or it could be, you might be interested in something totally different. So at this point, I think we should just terminate it.
I'm not sure what we could reopen it for, because it still doesn't qualify.
I know
Yeah,
that.
and there's no negligence or misconduct that you could.
It's an interesting case to discuss and all, but I don't think it fits under what we've.
Well, I think that we covered it a lot more often because of the emotional appeal of the sister at that time.
I think, legally that they have to request post-conviction testing done, and that would go to the DPS, and whether they elected to do it or ask another lab to do it. I think that's what, we suggested, and, many of us have done that type of testing, and there are lots of groups, including our own, that would be happy to assist the DPS if that's what they wish to happen.
Do we have to take any action at all? No, okay. So I guess we go on to the next one.
Okay, the next one is 13-08 DPS. It's a controlled substance case. The complainant is, is it Che?
Che.
Thank you. Che Patrice Hutchinson pled guilty to the felony offense of delivery of a controlled substance and was sentenced to 50 years of prison in Brown County, Texas. This has to do with the weight and the handling of the evidence. He disputes the police department and laboratories reported weight of the evidence used to convict him. The evidence in this case was originally 1 large plastic Ziploc bag and 2 smaller bags of methamphetamine. The officers reported they performed a field test on the narcotics at the crime scene. Of course, if they'd done that, they would have eaten up some of it in the testing of that. At trial, however, the officer explained he misreported that a field test was done on narcotics at the time of the arrest. Thus, no weight was lost on a field test. An informant who performed the drug transaction weighed the evidence at 4.8 grams, including packaging. Hutchison alleges that 3 original bags were thrown away at the police department and the evidence was repackaged in 2 separate bags. The police report that there was 4.55 with the bags, the 2 new bags, before it was delivered to the crime lab. The lab reported the evidence weighed more than 4.09 grams, and Hutchison believes the weight should have been reported less than 4 grams. Less than 4 grams is certainly the goal here. That's what the complainant is wanting it to be, and I think that's the basis of this. I think the last meeting we determined that we had jurisdiction, but dismissed the complaint ultimately because it didn't allege any negligence or misconduct occurred in the analysis. Our complainant has focused on the police handling of the packaging in his original complaint, but he's since resubmitted this complaint to clarify he's alleging negligence or misconduct in the weighing and reporting of the controlled substance by Herman Carell, a controlled substance examiner at DPS Regional Crime Lab in Abilene. He alleges that Mr. Carell failed to appropriately account for the packaging material and the substance weight as required by the laboratory's standard operating procedures. He also alleges deficiencies in the chain of custody of the lab itself. Because weighing of a controlled substance is part of the forensic analysis, I think it's the suggestion of our staff that we obtain a copy of the case file from DPS so we can do a further review of the allegations and determine whether or not we have a case.
The one question I've got is that the initial weight with the new bags was 4.55. The laboratory weight was also with the bags and got 4.09. So it was with the bags. So I'm
Yeah,
curious
yes.
if they took them out of the bags and it's still over 4, regardless of what the weight of the bags.
I guess unless there's, the only thing I could think of, unless there's something wrong with the scale where they've done something, they just don't know how to weigh stuff, is the allegation is.
Yeah.
I don't see how it's
Okay.
gonna get there.
Right.
There's just nowhere for that drug to go.
The reason I suggested getting the file is because I just think that's what we typically do, is take a look and make sure that what was done.
Right, he's alleging they didn't follow the procedure, so
Right.
it doesn't hurt to look at it and see if
Yeah,
the
we need to
procedures
look
are
at their
followed.
standard procedure on how they were supposed to do it, did they follow that, and make sure that the scales have been tested in terms of using known standards.
Yeah, I
So
think
I
you have
agree
to,
that would be our standard process is to try and get the laboratory's protocols, procedures, and the actual case file.
yeah, because,
Move that.
yeah, they'd have testing of the scales periodically,
Right.
whether it was up to the standards.
I'll second.
So,
We have a
Would it
motion
make a
and a
motion
second
that-
that we continue it until we get the
Yes.
material?
okay, someone make a motion.
I did.
He did.
Second.
Second.
Yes.
Vote,
Aye.
unanimous.
Okay, next we've got complaint number 1312, Fort Worth PD involving firearms. Our defendant in this case is Bart Ray Gaines, who was indicted in 2 cases in Tarrant County, Texas. The first indictment charged him with aggravated robbery with a deadly weapon and attempted capital murder. The second alleged the same charges with a different victim. These cases were tried together. He pled guilty to the aggravated robbery charges, and the state waived the charge of attempted capital murder. He was sentenced to 35 years confinement and a $10,000 fine. His complaint involves an allegation that Fort Worth Police Department's crime lab, specifically firearms examiner Ron Fazio, failed to explain a year-long break in the chain of command. I don't know if that's supposed to be chain of custody.
Well, I just put it in quotes because that's straight from his
It's a complaint. I think chain
Yeah.
of command probably means chain of custody.
Yeah.
Of a bullet fragment used to convict him. Mr. Fazio testified at trial the bullet fragment was fired from a rifle in Gaines' vehicle. The fragment was provided to law enforcement by one of the shooting victims many months after the crime was committed. He alleges Fazio neglected to explain where the bullet was extracted from, where it was stored, who handled the evidence between the time the crime was committed and the point at which the bullet fragment was provided to law enforcement. He asserts these omissions constituted negligence or misconduct by Mr. Fazio. On the jurisdictional analysis, it meets the criteria. Forensic analysis performed in the case on December 2nd, 2002, before DPS accreditation was implemented. The Fort Worth Crime Lab is a DPS accredited laboratory. The Forensic Science Commission has jurisdiction over firearms analysis.
Just to be clear on the jurisdiction, the commission could not review this case for negligence or misconduct because it's before the crime laboratory accreditation program went into effect. So the only way that you could look at this is if you felt like there was something in here to be gained from an educational perspective to issue best practices, observations about the quality of the science, so,
Okay.
yeah.
And which kind of brings us to the recommendation that we don't believe that the complaint states an adequate claim for review by the commission. The absence of explanation by Mr. Fazio regarding the handling of the bullet fragment by the victim between the date of the crime and the time the victim provided to law enforcement doesn't provide sufficient grounds for a claim of negligence or misconduct on his part. It's actually, from a legal standpoint, it's going to be one of those goes to the weight kind of things. Again, I don't know how Mr. Fazio would ever have any firsthand knowledge of any of that. I don't even know that that's part of his role as an examiner to inquire as to what the civilian did with it. Moreover, the forensic analysis occurred in 2002, and then, as already stated, we're barred from considering negligence. So our recommendation is dismissal of this complaint.
Someone make a recommendation? Second? Vote? Right. Unanimous.
Okay, complaint 13-13, Tarrant County Medical Examiner's Office, toxicology. Complainant.
Can I interrupt you? I'm
Sure.
sorry. Dr. Bernard needs to recuse himself from this vote and discussion because Swift's issued a report in this matter, so.
Okay.
But that drops us to 4, can we
No,
still?
but the way the rules work is that he still counts toward
Oh,
quorum.
it counts for a quorum,
Okay.
okay,
Yeah. Mhm.
that's fine.
Okay. You can stay in the room now.
He needs to stay in the room. This is not, you cannot go anywhere.
Okay. All right. For the remaining commission members, complainant Larry Martin Roche was charged with intox manslaughter from an accident that occurred on March 3rd, 2001. According to Mr. Roche, there were multiple tox reports in the case. He alleges that 2 of the reports, one from Swifts and one from forensic toxicology consultants, demonstrated levels of a prescription medication in Mr. Roche's blood that were insufficient to result in intoxication. However, another report from the Tarrant County Medical Examiner's Office showed drug levels high enough to result in intoxication. Mr. Roche alleges that prosecutors in Denton County used the Tarrant County Medical Examiner's report in discussions with him regarding a plea bargain. He took the plea deal based upon representations regarding the results in the Tarrant County Medical Examiner's report. After he was in jail, his family obtained a new toxicology report from the Tarrant County ME's office stating his first toxicology report was incorrect due to a clerical error. The Tarrant County Medical Examiner's revised results matched the other 2 reports performed by Swifts and the forensic toxicology consultants. He asserts he would not have agreed to a plea but for the incorrect Tarrant County Medical Examiner's report. He and his family have tried to pursue the matter in the court system but have failed, and he remains in prison. His sister Linda Roche writes to request the Commission's assistance. From a jurisdictional standpoint, the analysis in this case was performed in March 2001 before the DPS accreditation program was implemented. Tarrant County Medical Examiners is a DPS accredited lab. The Commission has jurisdiction over toxicology analysis. The recommendation is that this is a complaint that's more appropriate for the court system. The documents submitted show the lab performed a forensic analysis. Clerical error was made, the lab corrected its error, reported the correction to submitting law enforcement agencies. Further disclosures or correction obligations would be the responsibility of law enforcement and I would say the prosecuting attorney. The Commission should dismiss the complaint and consider referring it to the Innocence Project so that they may determine if any further legal action is appropriate. We should also consider informing the prosecuting authority should they can make a similar determination. And of course, we've had one recusal, and Dr. Perwani, who's not here, has also recused himself.
Now, I would think you'd be in a good position if this happened, because this is your area.
Yeah.
right? If this happened, how would you all handle it?
Well, I
Terry?
mean, if there was, if a plea or conviction was based upon erroneous evidence, erroneous lab reports, if that's what it came down to, we'd probably join the defense in a motion for new trial. That's.
I talked with the family member who submitted this complaint, and what she explained was that the attorney who represented the defendant, who's now in prison, recommended that he take the plea based on the Tarrant County first report, not the corrected report. And it wasn't until she submitted a PIA request to the Tarrant County Medical Examiner's Office that the family realized that Tarrant County had corrected itself because it saw the clerical error.
See, and again, from my perspective, in that situation, we would give everything over and so the defense attorney would be aware that we have these conflicting reports. I mean,
Right.
that stuff does happen. There's a difference in the reports or there's a correction, but there'd be an obligation, depending on the timing of when this was discovered. If we had it before the plea date, that should have been disclosed to them.
What we don't know is any of that.
Right.
We don't know whether What we do know is that Tarrant County sent a correction to the submitting law enforcement agency, in this case, the Denton Police Department. We have no idea if the Denton Police Department then turned around and told the DA that they got this. We do know what, I mean, you see the letter from Tarrant County in there, and what they said was, we're correcting ourselves, and please send this to anyone who you have sent this report to.
Right.
Whether that was done, we have no idea, so we don't know if the prosecutor even knows about it. What the woman I spoke with said is that the defense attorney has not returned her calls asking what is going on with this, and do you know about this? She doesn't even know if the defense lawyer
Right.
knows about it. So there's a lot of work that needs to be done that has nothing to do with the commission.
Right.
But I think, again, I think notifying, I mean, if it was the office that I work for, it would benefit us to have this reported so we could look at it. Because again, if it is a clear example of an insufficient lab report that is the correct lab report that resulted in the plea, then we take some steps on that. But as you said, that's one of the big challenges we have on a regular basis is law enforcement sharing everything they have with us, even though we're imputed to know it. Imputed knowledge isn't real knowledge, and so that is the question. But it may, if it is as alleged, it may resolve itself. I mean, there's always a way to undo a conviction if all the parties agree.
Yeah, but this is not our
No.
area, this
No.
is the court system.
This is the court system.
I really would like, I'm just curious, apparently what they're saying also here is that they somehow were involved in the court system and, but it's failed, so.
Well, I don't know if that's based
They
upon
filed
the
a-
attorney not returning their
Oh.
phone calls.
What happened, the attorney didn't return the phone calls, so the family member tried to file a writ on her
Right.
own.
Oh,
And it
okay.
was time barred. So
Okay.
she's done what she can do of her
Okay.
own accord, but what they really need is for the prosecutor and the defense counsel,
To
probably
talk.
new counsel, to talk about what that report means for that plea and
And
what
whether
should be
they're
done.
even aware of it.
Right.
Right.
Yeah, I think that's, if we can, I don't see a downside even if we don't have jurisdiction to notify the prosecutor's office about
Right.
that. So.
I will call the Denton County DA's office.
Okay.
Okay.
And
But-
can we also, I mean, the other part is to, you know, the Innocence Project of Texas certainly now knows about this case and ask them to possibly help this family and this defendant.
Absolutely. I will get in touch with her as soon as I get back on Monday, and I'm actually really eager to get some more information on this case. We have a really good board attorney who's in Denton County, so if we can help him out, I think we'll have a good chance of being able to do that.
Great.
But our side, I think we just
Dismiss.
Dismiss the claim.
Take a motion.
I move that we dismiss.
Second?
Second.
Aye?
Aye.
Unanimous.
I think that's it, right?
In that section, right.
I think we, number 4, I guess we can move on. Anything else? Art, do you have
No?
Okay, I guess this is yours.
Yeah, this is an update on the AG opinion request submitted by DA Rod Ponton. You have in your materials the opinion request that was submitted, the responses by our office and also by the state fire marshal's attorneys. We have not received a response from the Attorney General yet on that, but it will be really interesting to see what the AG has to say about that. I know that, and Chris Keneally's here and he can talk more about this, I know that the DA's office that raised concerns about the arson review did participate in their last science advisory work group meeting. So there's been a lot more dialogue. I did speak with Mr. Ponton at the TDCAA meeting in San Antonio. He was very gracious and I think really wants to learn more information. They're playing a bit of catch up, unfortunately, but you know, I think that's a lesson learned certainly for the fire marshal. So I don't have anything else to report on that. As you know, the DA also submitted a PIA request to us. We provided them a Dropbox folder with everything we had except for one legal counsel memo. We submitted that to the AG for an opinion. They came back saying that it was protected by essentially attorney-client privilege. So that's the only thing that was exempt from disclosure. So, and they seemed satisfied with what we provided because we gave them absolutely everything that we could think of, probably more than what they wanted. That's it for that piece. I don't have anything else.
Okay. So now we go on to number 6, which,
Act number
no,
five,
5, excuse me, 5. And this is, of course, the arson case review.
Now, I would like to say one thing before we turn it over to the fire marshal, which is that I sent around articles about this to y'all, but our fire marshal was nominated to be Texan of the Year by the Dallas Morning News. And the finalists, there were a list of finalists, and he was a finalist in that process. And ultimately, the Texan of the Year, I think, was the first responders in the West incident. But obviously, we were very proud that the fire marshal got that. And I think the Dallas Morning News recognized him both for his leadership on these issues, forensic issues, as well as the way that he responded to the West Texas tragedy. So we sent that around to folks, and with that, Chris?
Well, thank you for that, Lynn. It's probably the only time you'll see my name and Matt McConaughey on the same list. So man's got those limitations, and good looks won't be there for me. But that said, my mom loves me, though. I'm that much I know. Well, we've just got through our first year with the formation of our Science Advisory Work Group and those 4 fire investigation forums that we kicked off in January in Houston, and we alternated between Houston and Plano 4 times over this past year. And as you recall, the structure of those forums is the first day and a half is training. And so much what's in the Forensic Science Commission report on fire investigations, I don't know how else you fix it without significant investment in training. And so we facilitate that. We invite any fire investigator, both public and private, around the state and beyond, quite frankly, to attend. And it's an 8-hour class by one of our Science Advisory Work Group. I call it the SAW. We have an acronym for everything in government. But they do an 8-hour class, and the next day, touching on another recommendation in y'all's report, is making sure that fire investigators are up to date on the latest science. All of the panel members give an update from their perspective, such as Dr. Pirani being a forensic pathologist and scientists, electrical engineers, that sort of thing, that impact fire investigation. And so that's a day and a half of training. Then the next 2.5 days, we go into our retroactive case reviews. And, I'll let Nick speak to this here in a minute, but certainly our partnership with the Innocence Project of Texas, we greatly value. To say that all the folks amongst my peers embrace that, I'd be lying to you. But I think we're winning converts more and more. I think I know it is a great partnership because, one, I value transparency. I think government's always better when it's transparent. And certainly they've been very helpful, and I think we've been helpful to them in reviewing the cases they bring forward, because we only review the State Fire Marshal Office cases, but they bring those that they find that may not be ours, and we do those reviews. We have completed 6 reviews thus far. 5 are public. 1 was finalized at the Plano meeting in December. I'm waiting on our subcommittee within the SAW, Dr. Icove and Kathy Krause, to finish that letter on that case. It's disseminated to the panel, make sure they're in agreement with it, and then we forward it to the district attorney, and we let them digest it for 10 days, then we make it public. And so that one should be done early this year. We have about 5 more cases that we're working on for the February forum. That'll be the last week in Corpus Christi. And so we'll meet in February, May, August, and December. And we're going to change it up. The Houston area, as far as training, the Pasadena Fire Marshal Office has done a real good job of training. And my God, Texas, I've been here my whole life, but it's a huge state, and you're trying to service it and without incurring a lot of travel. We're going to include Corpus Christi, as I mentioned, and San Antonio, and we'll go to Plano twice just because we have such great attendance there, and we hate not to pull out of the Metroplex because of all the denseness of the population there. We, speaking, what Lynn was talking about with Mr. Ponton, and certainly we responded to that Attorney General opinion request. We're hoping that it works out the way we want it to. I think we find out maybe in April for that. But one of the things that was kind of an oversight on our part, and I freely admit that, was while we notify the DAs when we're looking at a case for review, we have never made it a real sincere invitation, not to exclude them, but we always work closely with DAs and felt, well, we had the Innocence Project there, but it came up at one of the classes I was teaching at a legal CE course early in the year, and one of the assistant district attorneys from Harris County asked, well, why aren't we there? Good point. And so we corrected that. In December, we had very good attendance from the various district attorneys in those cases that were from their various jurisdictions. And that'll definitely enhance the process, because now we have an insider that's going to help us with sometimes still getting data that the panel needs to make a decision on that case. The process is working pretty well. We continually tweak it. An example from the fire stakeholder groups, as far as fire investigators, I should say, in January of last year, they said, well, we really want more representation from public fire investigators on the SAW. And I said, well, we're state public fire investigators, and well, y'all are too close to it. We need someone else. So kind of left that alone. It came up again in March here at another conference, and I said, okay, fine. So we requested CVs for those who'd like to serve on the panel. We got quite a few, and we had we made not one, but two choices. We included Devin Palmer, who's with ATF. He's on their national response team for the Western Division, has very good credentials. And then Aaron Wolverton, who's the chief investigator with the Austin Fire Department, very good credentials as well. They've been added, so now we have a total of 8 members on the SAW. It's majority rule when they vote on determining the outcome of a case. So we're hoping that facilitates further buy-in from the fire investigators across the state, that we're very transparent, there's nothing to hide. We've always invited the fire investigators, when that case is being reviewed, to come and attend. They're a resource, plus they see the process. And I'm very encouraged now with the DAs attending really well, that they also see how the process works. And hopefully it helps also fire investigators, because they'll have a better understanding of arson cases, and maybe they'll take more of them in the future because they have a better understanding of them. So hopefully those will be some long-term gains there. And then we're very excited. We're going to be in February at the Academy of Forensic Sciences conference in Seattle, doing a presentation from Jeff Blackburn and myself. I know y'all have a number of presentations, so we look forward to seeing those up there. And then, I will tell you that this, what we're doing in Texas, and I give a lot of credit to you all for those 17 recommendations. We've touched all 17. Some are keep on going and never end, such as training. An example, our training has doubled from comparing fiscal year 12 to 13 in the State Fire Marshal Office. And Texas Department of Insurance has made a huge investment in us, and we're very appreciative of that. We've also added an electrical engineer with a strong forensics background. And we also added a criminal analyst. And we make those resources available to fire investigators around the state as well, to help them with their cases. So it's just not for us. But with that, we are getting a lot of attention, fortunately mostly good. And other folks around the nation are wanting to replicate what we're doing in Texas. And so I give a lot of credit to you all with the report and setting that guide as we went forward and created this process that's never been done before in the United States, and even conferring with an investigative report out of Denmark, because they're having similar challenges there. So it's even going beyond the United States. So we'll continue to work with that, and the cases going forward for review. We also include the Innocence Project because the next level, we've done all our capital murder cases that we had convictions on. Now we're going to the lesser levels of arson convictions, and we'll have Nick up there as we do that review. Again, transparency. So everyone knows what we're doing. Nothing's being hidden. It's all done out in the open. I guess I can let Nick come up here and say what, and then we can take questions after that, if that's okay.
I don't have too much to add. I think he covered the bases pretty well. In terms of the cases that we're looking at, we're still in the process of trying to find and fill in the gaps of the information that wasn't originally returned. We're still trying to get more questionnaires back, some trickle in here and there, but we still haven't added any more cases that actually need to go to the SAW for review. That could change. We'll continue to try to fill out those numbers. I mean, like we've discussed before, there's a number of cases that might fall through the cracks. As they show up, we'll take a look at them and get them submitted. But otherwise, I just want to echo what he said. The great work that the Forensic Science Commission is doing, the great work that the Fire Marshal's Office is doing, it's being recognized not only in Texas but nationwide, and it's just something that Texas can be proud of, and we're happy to be a part of the process.
Any questions? Okay, thank you.
Thank you.
Can we handle this without Kerrigan?
Yeah.
Okay, the next topic is going to be the hair microscopy panel. That's a big day. Okay, this is the update on that. I just realized their meeting was on the 50th anniversary of Kennedy assassination.
That's true. So as you recall, at the last meeting, the commission appointed 4 members of the hair microscopy review panel, and that includes Dr. Kerrigan, Dr. Pirwani, Richard Alpert, and Bobby Lerma. And we had a meeting at the DPS laboratory in Houston on November 22nd. We had sent out letters to all of the state's crime labs asking which laboratories had performed microscopic hair analysis at any point during their existence, essentially. What we found was that there were 20 laboratories, mostly located in the major metropolitan areas, plus the DPS system. So 12 of the DPS labs had done some form of hair microscopy, plus there were another 8 labs that had done that work as well. It was a very spirited discussion. It was an open meeting. And what we tried to do was get the group to achieve some consensus so that the committee could take that consensus back to this commission. There could be a discussion and we could move forward. And Bobby was there. And so if you look behind tab 4, we have the memo that we sent out. I'm sorry, not tab 4. Tab 6.
There's nothing there.
Tab 6. There should be.
Oh, 6,
Yeah,
I'm sorry.
That's okay. And basically, it summarizes what the agreement was. I don't know if you want to comment, Bobby, on those 6 points that we agreed to. But basically, Lee and I had looked at the legal databases that cover appellate cases and run a search, a very broad search for any cases that talked about hair analysis, microscopic hair analysis, hair microscopy, anything like that, and sort of narrowed it down to a group of about 85 cases where it looks like some form of microscopic hair analysis was done. We have that list. It doesn't mean that there was a positive association. It doesn't mean that the hair had any impact. It doesn't mean any of that. Just that in the appellate decision, there was a discussion to some extent of hair analysis. So we had that list. We agreed that all of the laboratories would provide the names of their hair examiners to the commission so that further searches could be run based on the names of the examiners. And the folks who were there represented the laboratories, but we also had a public defender, Bob Wyckoff, and Mr. Wyckoff is extremely valuable to the group because back during the Bromwich review that I'm sure you're all familiar with down at HPD, at the end of that process, he was given a list of 135 cases where supposedly the serology was a major factor in the conviction. And he reviewed all of those cases. Ultimately, he determined that really the reality was that far fewer than 135 had that kind of impact. But he's been through this type of process before with the Bromwich review involving serology, so he knows sort of some of the logistical issues involved in a large-scale review like this. We also had Jeff Blackburn there and Jack Rhodey from the Galveston County District Attorney's Office. They're making suggestions from the prosecutor's perspective. I also attended the TDCAA meeting in San Antonio. It's their annual elected DA conference. Their board met during that conference, and they're all aware of this. I talked to Rob Keppel, and he's the executive director, of the TDCAA. They're on board to help out however they can. They're eager to see a list of cases. So that was a positive development. The laboratories themselves are at different stages of identifying hair cases. Now, as you might imagine, for a laboratory system like DPS, just using them as an example, this is a massive undertaking because most of the cases that you might have troublesome lab reports or testimony would have happened probably in the 80s at some point. That stuff might even be on microfilm. It's hard to track down. It requires a lot of human resources that DPS really doesn't have. Now, some of the other laboratories have already given me the list of all of their cases. They've gone through, some of them manually, box by box, and we have 4 different labs as of yesterday that have reported lists of cases. So that's a good thing because that's certainly a place to start. So what we asked was that the laboratories either provide us their list of cases if they've elected to do a review of everything, or if they can't do that because it's too taxing, to provide a list of 10 cases chronologically from each decade so that we can start with the subsampling. So the laboratories are in the process of working on that now. And then we ask them to provide a cost estimate so that the commission can support them in the work that's required. Now, I can tell you, so far, I've been asking the labs, are you going to invoice us? The ones who've already submitted spreadsheets to me, and most of them have said no, but some, I think, will. So we need to do a budget allocation to cover this project, I think. That's certainly one action step. We need you all to discuss what has been done here to decide whether there's anything else you think should be done, whether you think the panel's on the right track. And then the final thing is that once these cases are gathered, we still have to go through the process of identifying appropriate criteria to flag cases. So for example, what in the testimony really would be considered an error? We know the FBI has already gone through this process and that they have error categories. I believe there are 3 categories. But what we've promised, and I think what is critical to the integrity of this process and to buy-in by all of the stakeholders, is that the commission really work with the key stakeholders, being the lawyers and the scientists, to come up with a criteria that the Texas stakeholders feel comfortable with. In other words, that we don't just adopt what the FBI did. Because, frankly, the FBI process, from what we understand, really was a process where it was the attorneys that got together and decided what the criteria were going to be. And I think the scientists in our forensic community here would really like to have some input into that process. And I think it would be a better, more robust process if that happened. So basically, those are the 3 things. Number 1, any feedback you have on what's been done so far. Number 2, an allocation of funding. And number 3, I would say delegation to the panel that they are able to pull together a group of attorneys and subject matter experts to establish the criteria for review.
How many cases, you said we've had some labs, how many cases have been reported to us?
Well, so far, you know, I just got one of the labs last night, but two of the labs, Swift submitted a list and Bear County submitted a list, and they both have, there are only really a few dozen cases on the list, which does not surprise me, because what they did was they narrowed it down to positive association. So
Okay,
they didn't
which
just
makes
give us
sense, yeah.
anything. They didn't just give us anything and then, you know, we sort through it. It was cases where there was a positive association. So that is very helpful.
Yeah, because the negative, we don't care.
Right, I mean, if they ruled out, if there
But they
was
said
no
there was no match,
association,
right?
if it said there was no match, why look at it?
So
You
you're
would've gotten
talking,
over 3,000 cases if we'd have just given you
Right.
all of them.
right, but the positives are the only ones. You're talking a few dozen, and but Dallas would be a main, because it had a robust laboratory, and it's always had it since the 70s.
Yeah, we started, the first list is coming for 1991, and then we'll have to go by each year trying to chase them down.
So for the cost part of it, you actually might have some constructive input on what we're talking about. I mean, do you know how many man-hours and what the pay of those men and women that did this?
I can get that, I don't have
Because
that.
that's the real question, as we get these bills.
Well, Pat Johnson and I have talked about that a little bit. It's really up to the discretion of the laboratory whether they want to invoice the commission. And frankly, for some of the labs, it's more of a hassle to invoice than not because of their bureaucracy. So they're just doing it themselves. I know that, I want to say that we had talked about that for a forensic examiner to do the work at an overtime basis, because they obviously can't, we don't want them pulled away from bench work to do this. I think it would be about $50 an hour, we estimated. So I think what I would suggest, the commission does have the budget to do this, is that we set aside money, and I don't think we'll use this entire pool of money, but that we set aside $50,000 for the project that would cover any invoices that we receive. We'll ask the laboratories to sort of keep us up to date on their expenses and whether they think they'll go over, say, $2,500 or $5,000 a laboratory. And that way we can track it. If we need more, we'll let you know. I think it's going to come in under that, just judging by what we've done so far.
So you seem to have indicated that the commission has gotten some invoices to this point?
We have not received
Oh.
any invoices. All we've received are sort of estimates from folks on what they think it, and Linda's lab has some of these cases. Do you think $50 an hour would cover the overtime, or?
It would. The problem is, at this time, I have no idea how long it's gonna take because our files are so fractured. We have some on microfilm, some, I started this crime lab in 1990, and the file preservation methods before that, I don't really have a good handle on. So, it's gonna take some time to track all that down.
So some labs will cost quite a bit more money just because of the state of the record keeping and the resources that exist in the lab. If you've got a small lab, some labs, like the Pasadena Crime Lab, they came to the meeting already with a list. They had done all the work before we even started. But that doesn't necessarily hold true for all of the labs. And depending on the workload and the demands that are currently there, you might have some labs that need a lot of support in order to generate a list, and others that were able to do it without too much trouble. You know, Tim Slider, I think, did the work for Swifts, and he'd been on it from the get-go. I mean, I know he started working on it as soon as the stakeholder presentation happened. So it's gonna vary from lab to lab, but what we don't wanna do is put the laboratories in a position where they're strapped for resources to do this, and they feel like they have to take people away from current bench work, that it adds to their backlog time. I mean, that's not helpful.
But the thing is, though, what we're really interested in is only the positive match cases.
Right, and they,
Now,
yeah.
is that all that are they reporting, or some labs also reporting every single one?
So far, what we've gotten are, I think, primarily positive
Yeah,
identifications.
because you might want to tell labs, you know, you just have to give us the positive ones.
I think the Pasadena PD cases were everything, from what I remember.
That was a little bit of everything.
Yeah, there was a little bit of everything.
Yeah.
But since then, the larger laboratories, Bear County
Just, okay,
and Swifts, they tried to help narrow it down.
okay.
You mentioned,
Go ahead. Go ahead.
you mentioned at the outset about different areas of the budget today. Something you want us to do with that now with your recommendation, or you want to just keep that in mind for?
I think we need a vote today
Okay.
because
Okay.
I don't want to, first, if the labs start submitting invoices, I would like to be in a position to pay them.
Well, I'll make that motion that we set aside 50,000. I would like to see in there, I guess, some kind of tag or something that comes along and says, you know, that they got to let us know when it's going to be big, or, you know, keep,
Yeah, you don't want to
Invoice.
bill for 50,000.
yeah, don't come in with 50.
Well, why don't we, if you want to make that motion now,
Yes, I'm making that motion.
second,
Second.
vote,
All right.
unanimous.
And just to let you know, before I came up with that number, I based that number on the feedback that I got from the laboratories, an estimate of how many hours it would take. You know, the lion's share of the work will have to be done at DPS, and it will need to be done during overtime hours. So Pat and I had a discussion, and we thought that if we set aside an even amount for each lab, that they should be able to do it within that budget allocation. Is that a fair description, Pat?
I think it's been a while since we talked about that. Sounds about right.
Now, how many labs again did you say?
20.
So there's 20.
4 have already submitted a full, 4 have already submitted lists that have quite a few cases on them.
Okay.
I mean,
26 in 1991, and that was the peak year of all the hearing analysis.
That's not a lot of cases. That's all.
but we didn't think there would be.
Yeah, it looks like there's not that many cases.
Yeah, we'll have to see what happens with
Now we have to see the
DPS.
testimony. Yeah, right, I know. But I mean, every day we're reducing. I know DPS is the 800-pound gorilla, all right, and everything. But, but as the others come in, because if we've got Dallas and Bear County, that's 2 major ones. I mean, and, the other cities, you know, Houston.
Houston will be quite a few.
Yeah, Houston.
We've already gotten a preliminary list from HPD, but it doesn't have everything on it, because what we asked them to do, remember, was a subsampling.
Right.
But what we do have is, even with the current list that we've got, we have a good place for the group to start. Because
Yeah.
it takes time. I mean, just the lawyers on the panel are really, the DA and the public defender will have to work together to reach out to the prosecutors to get copies of the transcripts. I mean, it's not a small or short-term endeavor. It's gonna take a long time, even to get through the cases that we've already got.
Are you gonna pull the cases that are pleas?
We talked about pleas, and I think that's something that it will be really hard to do, because the issue is, you know, to what extent did the Hare testimony impact the plea decision? And as Bobby described, that's something that's sort of in the head of the defense attorney and the client.
Right.
And this is a
So-
long way back,
Right.
so.
So we have to, we'll consider that throughout, but I think for now, we're just trying to focus on the cases where there was a conviction through a trial that actually has a transcript to look at. Because remember, most of the places where these cases went wrong were in the testimony,
Right.
not in the actual laboratory report.
Yeah, probably the employees have the lowest priority, when you start reviewing. Leave them towards the end.
I have a question about the appellate cases, because I fortunately had to miss the meeting, but I thought that might be productive in finding those. Where are we in the process? Have we just, because I understand a word search can be deceptive. Like, if you just do a hard word search, it doesn't mean that the word, you can have the word you're looking for, and then you can see harmless or something else, the opinion. Have we actually had anyone go through and read each of those opinions and see if the opinion itself speaks to a potential concern about the hair analysis?
So we've distributed those, Lee and I narrowed it down and looked at the appellate opinions. We've got about 85 cases, but it's still kind of tricky to tell, even from the appellate opinion, what happened at trial. We sent the list over to iPod. They cross-referenced it against cases that they have in their file and found that there were quite a few that corresponded.
Yeah, and for us too, because that list only had the case sites, so then we had to go and try to find the full name and then cross-reference it with, our files. And I don't think we got completely through that process, but there was at least 20 or so cases that we had some sort of file on, whether it be waiting for an investigation, closed correspondence, but we had files on some of these going back to, 5-6 years ago. So, there will be cases, I think, like you were saying, that once it gets whittled down, I don't think the numbers are going to be as large as expected, but out of those, there might be some meaty cases that come out of it, so.
So is there, besides iPod, is there someone else that's screening and reading those cases to see if there is any meat in the opinion?
Not yet, because we wanted to get we need to get a vote from the commission that this is the way you all want to proceed before the attorneys, Bob Wyckoff, Jack Rohde, either Jeff or Nick, before they have to pull transcripts, right? So
Right.
in order to really get an idea of what's in there.
Well, but, yeah, they do, but again, I think just the basic reading of the opinion, I assumed would exclude some cases from
It
consideration.
did, because we started with 400.
Okay.
And we're
okay.
down to 85.
Okay, I get you now.
Yeah.
So that's what I was,
Yeah.
so the 80 cases have some basis for, it's not just a word, it actually has that.
Right, the
Okay.
400
All right.
was the initial result when we just ran the word search.
Okay.
So then we had to go through the case summaries, and then we had to pull and go through that process, and what we came down to about 85.
So you eliminated 75%.
Right. Some of them just had absolutely nothing to do with hair microscopy.
Right.
Others, we saw that there was no match. But some, I'm sure that even that group of 85 will probably be whittled down further once they start looking at
Have
it.
those cases been divided into jurisdictions, so we know how many cases came from Tarrant, Dallas,
Not
Houston?
yet.
Okay.
Not yet, but that will be the next step.
Because that might facilitate, you bring the involved DA's office into the process, that might facilitate getting the transcripts and stuff.
And TDCA has asked us to do that.
Okay.
So they would really like to get involved on the front end, which is great. They want a list by jurisdiction.
Mhm.
We sent them our sort of summary list. So we wanted to get your vote to go ahead, and then we'll start working on the logistics of all that, bringing all the stakeholders in, working with the labs to see where we're at.
I guess we should have done the plan first and the money the second. So, we'll make a motion.
Well, yeah,
it doesn't
there is a
matter.
motion on the floor.
Right. So,
You need a motion that we move forward?
No, I don't know that, did we get a vote
I
on
don't
the
know.
we
budget?
voted
voted on
the
the
money.
We did,
have the
okay, we
money.
did,
We
all
did.
right, good.
So we need a
Now
motion on the
is,
plan.
do you want officially to go,
Yeah.
Yeah.
okay, this is something we'll make a
I
motion.
move that we move forward with this project.
Second? Vote, yes?
Aye, yes.
Unanimous.
And then I think the final vote that we need is that the panel be able to bring together whatever subject matter experts they feel are appropriate, including hair examiners, to look at developing that criteria that we talked about.
Does that vote also involve an outlay of funds to pay these
Yeah.
experts?
No, I don't think they're gonna be paid. I
Okay.
hate to
I
say
have
it,
a
but
question. How many hair examiners are there now in the DNA area?
at least two were at the meeting.
You know, it's certainly reduced. I mean, the
That's-
frequency of analysis is reduced a great deal from where it once was. We've got 3 people in trace, but they're not doing a tremendous amount.
Yeah, I would think that, you know, most people would like just, if they were confident about something, they would just jump right to DNA.
Well, a lot of the here examiners are looking to see if you have roots to then move it straight over to DNA versus all you have is a shaft and you're having to make some comparison or move it over to mitochondrial if it's appropriate.
Yeah.
We
I mean,
do a
there's
lot
a-
of DNA analysis of hair, but we require the hairs to have been looked at by a competent hair examiner
Right.
before we do anything in the lab. We
Yeah.
don't have, you know, really.
Well, I would think that the tendency is look at it, looks, well, send it on, can't do any harm.
Well, sometimes you exclude it and that removes a
Right,
waste
yeah,
of
I
time
mean,
by everybody.
yeah.
So they're, I mean, they do
So,
keep busy
no,
doing
yeah, I
that,
could
but-
see, it would, their work would be basically excluding, rather than giving positive or something.
So you need a motion that we move forward with engaging these experts?
Mm-hmm.
So move that we move forward with getting subject matter experts and attorneys to work with the panel to identify criteria.
Second.
Vote? Aye, unanimous.
Is there another meeting date set? for the
Not
panel?
yet. Dr. Kerrigan, I'll talk to her about that because
That's-
I think she's chairing, she's
Yeah.
chairing this panel. You might want to ask, we could ask for any feedback from the labs here that are affected by it, if they would like to.
Yeah.
They talked about it yesterday at the TACWID meeting, but if they want to address. the
Does anyone
question-
want to say anything about this? Get up and say it.
Bill?
Yeah, and we did discuss it yesterday in our association meeting. And I think in the next 2 weeks, we'll have a position paper put together to publish to the commission on how we felt it's going. But I think our main concern yesterday is just having a sufficient number of subject matter experts on both the committee to come up with the criteria and the review committee, so that, you know, you just don't have one subject matter expert on hair. You have a sufficient number to be able to look at those objectively. So that's our goal, is just to make sure we get enough subject matter experts.
You all have a number in mind?
I don't believe we've really got that far, because we don't know how big the panel's gonna be, you know? So that may be some further discussions further down the road. You know, as y'all are looking for SMEs, you know, we may be able to help y'all identify the ones in our association, and then maybe we can,
Put the names forward.
yeah.
Seems reasonable.
Any other comments? Okay.
I will work with Bill on getting the names and the number that they feel is appropriate, so that we can make sure that the association has a vested interest in moving forward. I think that's it. on hair.
Right, let's see. Okay, it's number 7. Again, you're up. This is the DPS Houston self-disclosure.
Right, so we had this item on the agenda in case the Court of Criminal Appeals had come down with a decision in the ex parte Cody matter, which they have not yet.
So,
I'm just looking over there to make sure I haven't missed anything, because I know that it would be picked up if it had come down, but it has not come down. So we'll just leave this item on the agenda until they do come down with a decision, because it will be pretty important. We should probably discuss it quite in detail. The DPS lab does not, they're sort of waiting also
Right.
for the decision to come down. So we'll see where they stand with retesting once this all shakes out.
okay. Next section is the white papers.
Right, so this is forensic development generally, and there are quite a few items under this including some training funds that we would like to have appropriated. So we distributed the white papers, so that was good. We've gotten some really great feedback on those white papers, both from inside the state of Texas and externally. And in fact, there's some legislation sort of floating around at the federal level that Senator Cornyn has developed in conjunction with Senator Leahy on forensic science reform efforts. And they know that we have these white papers out because certification, of course, is part of Senator Cornyn and Senator Leahy's bills. So people are really starting to recognize, I think, the efforts that Texas has made in addressing some of these issues. I don't know if folks have received any other feedback, but those white papers, of course, are sort of the basis for the academy presentations that we'll be doing in, actually next month in Seattle.
Yes.
So we should get more feedback there as well.
Do you think there's going to be, this new National Council of Forensic Sciences is going to be involved in matters like this?
I think that's the idea. They just haven't done anything with it yet that I know of. I mean, I know that they're trying to go through the process of appointing commissioners, but I don't think they've settled on who is going to be on the commission yet. I know they're working on a draft charter, I believe I heard yesterday. Is that, Brady, do you know what the status of that national commission is?
We had some folks that were at SWGDAM yesterday, and they were told during that meeting that they would announce the members of the commission today at 11.
Oh.
So I'm assuming
what?
that's
No,
Eastern
11.
time, so that should be right around now.
They 10 o'clock, 10:08,
So it's been announced at 11?
That is my understanding.
8 minutes ago. So, yeah, so, so basically, I think the National Commission will work on certification issues. I'm not sure about the defendant notification, but I know they won't be conducting investigations or anything like state commissions tend to do,
Right.
but they will be there to try to sort of help set universal standards in the country for forensic sciences, to help support research that underlies a lot of the disciplines and so forth. I don't know if anyone else wants to talk about the national legislation.
Yeah, we haven't heard much else about what the content would be. We're waiting anxiously to see what type of national legislation is before.
What we usually get is, I get a phone call like, oh, this is coming out, Senator Cornyn's releasing this, it's being pushed through, it'll be done right now, and then I guess other things happen in Washington and it gets delayed. So that's sort of the pattern, is like a big rush, this is gonna come out, and then nothing, we don't hear anything for a few months, and then another, this is a big rush, it's gonna come out, and then we don't hear anything. So we're still in a holding pattern, but we're very fortunate because we have Brady, who keeps track of all of this very closely and gets information and can help us make sure that we're on the lists. And so we will let you know what else we hear on that. So there are a couple of things that we want to talk about in terms of training.
Right.
One is extending the Crime Lab Manager Academy, the West Virginia University training, to 2 other locations, one down probably in the Houston area and one in the Metroplex area. We got the proposal from West Virginia. What we decided to do based on the evaluations is have just the first day and the third day. So we're going to reduce it to 2 days because people really, really liked those 2 days of training. So based on that feedback, we thought we could offer that to a wider group of folks from the laboratories. They'll do a group of 30 like they did last time, which allows for small group work. And what we would do is just ask the laboratories in those areas to designate people. And what they're trying to do is get sort of the next group of leaders in the laboratory there. Because the last one we did had mostly lab directors, some of whom won't be in the laboratories all that much longer. So we want to focus on that next group of leaders. We've had laboratories and facilities volunteer to host it. I know HPD has volunteered. The Sam Houston campus in the Woodlands is an option. So we'll find the best logistical space to host it in, but we need y'all to allocate the money to support that proposal, and we do have it in the budget, so it would be $50,000 also for this project.
I think we should, someone make a motion.
I'll so move.
Second. Vote, aye. Unanimous.
Okay, so the next area that we need to talk about is also in the area of forensic development training. I was approached by Brian Gestring, who basically, I guess he's the director of the Office of Forensic Services in New York. And obviously, Texas and New York have a lot of differences. We spend a lot of time talking about about all of our differences at our meetings. But there is one thing that we do have in common, and that is a shared desire to provide as much high-quality, low-cost training to forensic examiners as we can. And I think in the spirit of that, what we would like to do is get your authorization to do a pilot program where we can do web-based training that's free of cost to forensic examiners in the 2 states, that is supported by the commissions in the 2 states in terms of financial funding. And what we want to do is, Askclad Lab has this supplemental standard, and it's standard 5.2.13, and it requires that training of forensic examiners include the application of ethical practices in forensic science, a general knowledge of forensic science, and applicable criminal and civil procedures. And so what we were thinking about doing is offering 2 web-based courses designed to address that Askclad Lab requirement that the vast majority of laboratories in each state have to contend with to begin with. So it would help them offer free web-based training to their folks using faculty that are independent and outside of the laboratory systems. There are some faculty who who are widely known. Dr. Paul Voss is one of them, who lecture on these subjects nationally and I think probably even internationally at this point. But what we'd like to do is get your authorization for this. We think it would cost each state about $11,000 to offer both sets of training. And so it's not that much money.
I said it's cheap.
And it'd be about $9 an examiner per course. And by sort of pilot testing it, what we would try to do is see, okay, if this goes well and people like it and it meets the Askclad Lab requirements, then we can seek feedback from our examiners and say, okay, what other training would you like to see? Discipline-specific training, other management training, and we could roll it out further if it works and if it fits within the budgets of each state. So the New York Commission already has access to this live meeting technology that allows hundreds of people to join in and to participate. One of the things that the Askclad Lab requirement imposes is that there be an opportunity for interaction in training, that it's not just, you don't just get to sit in front of your computer while you're doing other stuff and the video's playing. So what we would do is leave it to the laboratory's discretion. They can show the training and then have a discussion, or during the actual live piece of the training, there will be opportunity for back and forth as well. We presented it to the TACLID yesterday, and they seem to be supportive of the idea because, of course, for them, it's always the training budgets that get cut first. So to the extent we can support them in offering high-quality training where their examiners don't have to leave the laboratory because, travel time and costs are an issue as well, we'd like to do that. I don't know if y'all have any feedback or comments.
I believe it was it was pretty overwhelming in the meeting yesterday that it was a positive step towards training. Like you say, our training budgets get cut first, and it's hard enough to try to get the technical training you have to have, you know, and then try to piece in the ethics and the other soft training you have to have. So we're very supportive of it.
And we thought by sharing the cost between two states, I mean, that
Yeah.
literally reduces in half what we have to pay.
Do you want to make a motion to go into an agreement?
These,
I move that we pay for such the pilot program that was described, and allot that money.
Second, money will spend.
How much do you want to?
I
You said
think,
11,000?
Right.
we think it'll be 11,000
You
for
want to
You want to quote a little
Texas,
more,
but
maybe
maybe,
15,000?
15,000?
Yeah.
I move that we allot 15,000.
Okay, well, first of all, I think we have to, okay, we can wrap it all up into, anyone who makes a motion that we go into an arrangement with the New York, and that we allot 15,000. Anyone propose that?
I propose what the chairman just said.
Okay, second?
Second, yeah.
Vote? Aye, unanimous again.
okay, so there's another area of training that I wanted to talk to you about, that we discussed briefly yesterday. If you recall from our first set of stakeholder roundtable meetings, one of the tables that I think Edwin Colfax and Pat Johnson moderated, they talked about cognitive bias and forensic analysis. We haven't done any follow-up on that, but there's an opportunity to bring the researcher and scientist who's probably the international lead on these issues. His name is E.T.L. Dror. He could provide hands-on 2-day trainings to show examiners and lab managers what cognitive bias is, how it plays out in forensic testing, and I think he does some case examples that he works in to allow people to really see how that impacts everyone. I mean, we all are affected by cognitive bias to some extent. This is something that just came in front of me, so I haven't really worked it out completely yet in terms of what type of material he would provide. We raised it with the TACLID yesterday. The only feedback that we got was that someone who had seen his presentation before thought it's very science heavy. He goes a lot into the methodology that he uses to come up with the data that he has and to come up with the findings. So if he were to come, we would want to focus him away from that and more toward the practical understanding of what it is, how it impacts folks. I know that, is Ron Singer's here, and he's done a lot of his own research looking at Dr. Dror's papers and had some feedback from me.
Yeah, I have a binder full of stuff that he's published and others have published as a result of his work. And I agree that while he is certainly the most well-known right now that's addressing the issue and with regard to forensic science, he may not be the best to actually bring in, at least in the beginning. I think it's a more basic issue that has to be addressed, and I volunteered to send what I had to Lynn, and we'll go from there.
So I guess what I would ask for is just sort of a delegation to the Forensic Development Committee to look into this issue further, to see whether we might bring someone in and to expend whatever funds need to be expended within reason to move that forward. Or we can just bring it back to the next meeting.
Can I ask
Yeah.
a question? Do you think the presentations that you wear could effectively be done on the web as opposed to a generalized?
I think that's sure, certainly possible, of course.
You know, that would be something that I think is worth exploring in terms of cost effectiveness.
Yeah. The way this all came about was that this was one of the subjects that Brian Gestring raised that maybe we could do as a web-based training. When we asked Dr. Dror about it, he said he didn't think it would be suitable for web-based training, that he thinks you have to be there in a group going through the exercises to really understand. But but it doesn't mean we don't need to use him, we can just sort of explore the idea further and bring it back at the next meeting.
I think we'd benefit by having this fleshed out a little bit more,
Yeah.
what that would provide for us, what it entails before we
Yeah.
go any further.
I've
It's
had
certainly
kind
an
of,
area that affects forensic science and, you know, other aspects of the legal decision-making process. And to make
Yeah.
it available to as many people as possible, at least as a learning activity, I
You
think
know-
we need to look at all aspects of making it as available and cost-effective to the state.
I've had talks, I've been at talks, something like this. And one of the problems is the presenter. I mean, that's very important. Because some of the, you know, one or two of these people, you're lost in 10 minutes. And you kind of sit there and they get very technical in their terminology and you don't know what they're talking about. You know, they have their own, you agree?
Right, it's psychology as
It's
opposed
right,
to what
and
we're
you sit
used to
there and you,
doing.
what does he mean by this? And so, this individual, as you say, may be very good, but it's not being very good, it's also being able to communicate with your audience. And when you decide what the audience is, you have to then decide maybe who can communicate with them. So I think what this needs is an exploration and a review of the field to see how these people work out. And it might be interesting to talk to some groups that have had these people and see what the appraisal, you know, were after.
Yeah, I know that he's done training in Los Angeles, and I left a message for Dean Gialamas, but I just haven't heard back from him.
Right.
But maybe because Ron has done so much work in this area, he and I could get together and
That's,
try to come up with
And,
something.
and I think Brian probably has a lot of basic people that we could go to as well, so I can bring him in.
Is that-
so, I don't know, do we have to make a motion or
No, I
or
think we'll
just,
wait
you
till
just
the next
explore
Just
it?
continue this.
Yeah.
Okay, then, yeah, I think it's a good idea to explore it. Someone wants to suggest we take a break?
Yeah, we can take it.
Okay. Is there anything more on this?
Yeah, there are a couple of additional points that I wanted to raise that come out of the certification white paper. And what you might recall from that is we had talked about how best to follow up on certification so that Texas is really leading on this issue and that Texas is deciding its own future with respect to that and not having the federal government or anybody else tell the state how it's going to roll out certification or mandating certification or anything like that. So we had a spirited discussion at the TACLID meeting yesterday about that. They are doing a couple of things that are very constructive. One is they're putting a group of their lab directors chaired by Sue Howe from Tarrant County. And what they're going to do is look at perhaps releasing a policy statement from the TACLID on where they stand with respect to certification. Hopefully it'll reference the work that the stakeholder groups did, because a lot of them were participating in that as well. And secondly, what we asked them to do was to work with us on trying to put together some form of proposal in anticipation that we're going to be asked during, if not the next legislative cycle, certainly the one after that, okay, what is going on with certification? And I think what the group would like to be able to do is have some materials ready to respond to legislative requests on that, both in terms of substantive education, which we have in part with that white paper, and, okay, how much are we talking about in terms of resources to support certification of forensic examiners in the state of Texas? So the TACLID put that group together yesterday. I think we'll be working very closely with them in terms of developing a proposal. So that's something that came out. I don't think it requires any sort of a vote, but just as an FYI, we're moving forward on that.
Will that also address just the training program itself? not only an examination or a testing, but what are the essentials of actually being trained to be an analyst?
I think that's part of what's contemplated. I know that they talked about basically just everything, soup to nuts. I know that there are a couple of universities, UNT Health Science Center and Sam Houston State University, that are working on a web-based platform to develop a lot of that training and to offer it. Is that,
So, I mean, you know, both Sarah and I have talked in our respective forensic disciplines. We're looking at developing sort of a training program to prepare analysts for the current certification exams in our particular discipline, say DNA. I had a question. Has there been any advances in terms of the certifying bodies relative to becoming ISO accredited, or, you know, we heard discussions at two meetings ago that they're looking towards different certifying bodies are trying to prepare themselves
right.
to be certified themselves to offer these accreditation exams. Anything
I know
happen?
that they're working on it very actively, but I don't know if any of them have received the accreditation yet. I know that IAI is certainly moving in that direction because Debbie Lieben and I we have spoken on occasion. I'm not sure if that's something you would know about, Brady, if any of those certification bodies have received accreditation.
I do not know.
They have not. SWAS has, we have 2 people, one on the board and one on the testing committee, and they are working on it and said they should achieve it within 2 years.
Yeah, I think it's a longer-term process.
I know that ABC said that they're working on it.
Yeah, I think ABC was
That's
the
ABC.
closest. Oh, that is ABC?
That's ABC, oh, yes.
So I think, and I do think they're the closest, so I would say we're looking at a minimum then of 2 years, and the others I think will follow after that.
The certification. And I think Jody should be linking to this. With the last legislature, they excluded the medical examiners. But I've heard some remarks since then. So they probably, if they would go with certification, but that should be easy for the medical examiners. Because, you know, medical examiners already have certification. Well, they should. And I think all the main offices now, everybody's certified or in the process of taking the test.
2 years.
What?
2 years if they.
2 years, yeah. Yeah, 2 years, yeah, I was at my office 2 years also. So if they bring up the certification of physicians, there should not be any problem. The problem's gonna be if they start talking about accreditation. But even then, that's not gonna be a problem, because even, you know, the private people are getting accredited.
Yeah,
You know,
it's,
Susie Dana is getting accredited.
yeah, the facilities are getting accredited. It's not the same accreditation.
No, I'm talking about the facility, I'm talking accreditation and certification. I'm talking about the accreditation of the facilities. But, so if that comes up, the certification should not be a problem. The accreditation is going to be fought by certain groups, such as Galveston,
Yeah.
which is probably the main opponent of it.
That deals with facilities.
Yeah, that's what I mean.
Not wanting to build a facility
Right.
that complies with the requirements,
Yeah,
but,
Austin too, I think's got a problem.
yeah, I know they're on track to build another one, but I don't know what the time frame is.
Well, I heard that they had appropriated $1 million.
Yeah, that's.
Okay, you know, that gives you an idea.
That must be $1 million for the project study.
That's right, yeah.
Is Dallas County accredited with the?
Oh, yeah.
Their new facility?
Name and ISO for the lab.
Yeah, the only major city I think not accredited is Galveston,
I think that's right.
yeah. And even Lubbock's is, if they wanted to, I don't think they're pushing it, but if they want, they were certified, they were accredited at one time.
Yeah, I don't know about El Paso. I'm not sure about out there.
El Paso, doesn't have anybody. That's what their problem is. But,
It would be hard to pass that accreditation then.
well, they said, yeah, I think that's their main problem.
So where do their bodies go?
They have somebody doing the autopsies, okay?
Have contracts.
Well, I mean, I think we've talked about this before, that autopsies are probably coming in.
Right.
And it is what it is.
Yeah,
People die in El Paso.
Yeah,
So-
I think they do. Yeah, I think the one thing that we talked about, and we see as it is, and we'll just have to address the same way, is if it comes in, those people who just don't like the result,
yeah,
rather than there is
No.
an impropriety or a poor practice, are gonna have to be separated out, and we do the same thing here.
yeah. That's, yeah.
There's, are we all set with certification?
Yeah, no, we were just looking more between ourselves, I think, to serve.
So the final thing in forensic development, as you, I'm sure will all recall, is we talked a little bit about trying to encourage laboratories in Texas to participate in the Foresight program. That's a program where laboratories collect data, and it's quite specific in terms of the data that they collect. They send it in to West Virginia University, and West Virginia University produces reports that the laboratories can then use to assess their own efficiency and to try to find points where they're doing really well in terms of efficiency in a particular discipline, or to look at places where they may need to become more efficient or could use resources better, or even to just try to say, okay, what's going on in this discipline? Do we need to keep offering question documents, for example? And the idea is that the laboratories can use that data over time to improve themselves in terms of the use of public funds, and also they can potentially use the data to collaborate with other laboratories in the state and say, okay, it looks like you all are doing really well in this area. What mechanisms have you used to make this area so successful? And then they can discuss it and maybe try to share information that will help all the labs. Now, we had raised this at the West Virginia training that happened in August. And then after that, I know that DPS in Austin is doing it. The APD Crime Lab is going to start working on that. And at the TACLID meeting yesterday, the group discussed that there is quite a bit of interest in using the Foresight mechanism to improve laboratory performance. However, it costs money to do a couple of things. One is to do the data entry because it's quite extensive. I mean, they want to know how much you spend on everything from your utilities to the toilet paper in the ladies' room. You know, I mean, they really want to know that data. And so what we talked about at the TACLID meeting was, if we bring the person here to Texas who is actually in charge of that program, his name is Dr. Paul Speaker, and talk to him about how the Texas labs can participate in a way that will provide them good data for efficiency, but that is not so extensive that they can't comply with the program, so it never gets off the ground. So the idea that was raised was bring him down here and have a meeting where everybody can talk about that, and then see what they can do to help the Texas labs, and then try to encourage as much participation as possible. And I know you all were there, so Brady in particular, I think, has worked on these issues at ASPAD.
You said that very well. One challenge we had in the Austin lab, so I'm the director of our Austin lab for DPS, I'm assistant director for our service. I was faced with losing this tool, maybe on a service-wide level, but then, or maybe at an Austin level. It was easier for me to do it at an Austin level to have more access to the data. But there is a lot of methodologies around the data we're entering. And so where I put my data into the system, I didn't necessarily have that one-to-one relationship with data from Georgia or data from another state. So the proposal that we discussed briefly yesterday was that could we have the developer of the tool and of the system come to us, and if we could set our methodology to be consistent across the state of Texas, then we may have more useful data to collect and then make decisions on.
So I think what I would like to do is throw that open for discussion. If people feel like it's a valuable thing, to basically vote to allocate the funding to bring him down here. Obviously, we follow the GSA schedule on expenses, so he would fly down here based on our rules regarding travel and all that. Have him come down and talk with the labs and see where we get. Do people think that's a good idea? Or?
Well, I think the overall goal or possible goal is very good. I think one of the issues is trying to figure out how much time you're spending on trying to collect the data for hair. This would be pretty, at least just what my initial impression is, very burdensome in getting all the data. Now, once it's collected, but that manpower issue may be fairly challenging as well, but, you know, I mean, I think it's worth pursuing.
Mm-hmm. Do you have to dedicate a full-time person to the project? Or?
We used a full assurance staff, but it was very cumbersome. And the case-specific metrics were very easy for us with our LIMS system. But the other data and the financial piece, which was, that was very challenging for us.
Now, Bill Gibbons is doing the same thing for APD, and he's using an intern to help with the process. There's been some question about how much access you can give an intern to LIMS within the policies and procedures of the laboratory, as well as are they going to be able to know the data and the LIMS well enough to collect it all? I mean, how will it work with an intern? But I think Bill can give us an idea of that once he's had that experience, so that folks can know whether interns serve a valuable purpose in this. That's something that Max Hauk raised, you know, use interns. I'm not sure if it's that simple, but it's something worth exploring.
I'd want to bring my
You get what you pay for.
Pardon?
You get what you pay for.
Right.
Yeah, I'd want my administrator to come down because she would be the one who would determine how practical and how much time would be consumed in trying to, since I have one administrator, as to whether we could branch that out to the different subdivisions in the laboratory to gather at least some of it, because otherwise all the other work would be we would be behind trying to get that done, or this would fall off to the side. So hearing someone say what it is, we could then get a better feel for, is it practical to do? I think the ultimate benefit, there may certainly be benefit, is just getting to there.
I also think that from what we heard in the presentation, Dr. Eisenberg, the first year is really burdensome, but then after that it gets easier. The other thing that they might consider working with Dr. Speaker is like, look, we don't want to enter all this data, but what we really are interested in are these metrics, boom, boom, boom. And what we all feel comfortable collecting are these metrics. So let's do that for Texas, and then the next year we can add another set of metrics. And then, you know, and that way you're only starting with a manageable piece.
Well, that's the advantage of bringing them down, is to him to tell us what, if we want certain things, what metrics are required to get what we need.
Right, right.
As opposed to just globally, how much toilet paper are you putting into the ladies?
Right.
I mean, we have a line item budget, so some things might be easier to recover than other things, but some of it I don't think will be that easy.
And I think some of the labs have very detailed line item budgets, and others literally, if they don't even know what their budget is.
Well, they may do a zero-based budget, and then they start all over every year.
And they just go to their authority asking for, look, I need X, can you give it to us? But they don't really see a breakdown of their budget.
That's me.
That's me. So we have quite a range of experiences, I think. But if you all think it's a worthwhile effort, we can bring them down and have the conversation.
I think it's worth looking at, and then we can determine is it practical or not.
So is the venue a, Texas Association of Crime Lab Directors meeting that you bring the individual to?
I
That
think-
seems like would be the best venue where many crime lab directors could evaluate for their system.
I think that makes sense. Whether they would want to have a separate meeting or just do it at the June meeting, they can decide, but we can figure it out.
As long as it's fairly well publicized, and somebody from my lab hopefully can.
So I guess we need a vote to expend the resources to bring Dr. Speaker down.
So, one question I don't recall, is West Virginia still getting any federal NIJ funds for this project, or it was basically, they created it, it's done, and there's,
I want to say they don't get NIJ money anymore, but I'm not positive. But they still offer it for free. I mean, they offer the data processing for free. I'm not sure how they support that, but maybe the startup money was enough to get them going, and they're,
well, I think it's still, if we have to invest in bringing this individual, I think it's a worthwhile investment, it would be nominal.
Okay, someone want to make a motion?
I recommend that we pursue this and determine what the budget would be to bring the individual to Texas to do a presentation to as many crime lab directors and laboratories as possible.
I second that.
Okay, vote. Aye, unanimous.
I think I'm pretty sure that's all the forensic development items that we have. Yep, that's it.
Okay, we can move on to,
Unless anyone has anything else.
let's see, number 9. Oh, the training video, Brady versus
Yeah.
Maryland.
We haven't done anything on that. That's.
Okay, we'll defer to the next meeting.
Yeah, I mean, it's really being led, I would say, by Judge Hervey's office. And I know they've started working on it, but I think they're having trouble finding forensic scientists who are willing to be actors in the video, which doesn't surprise me because I'm not sure I'd volunteer for that gig either. But we'll keep working on it with them.
Could just use CSI actors? They
Yeah.
already have the terminology down.
Right, yeah, we'll just bring them in from
Sure.
Hollywood. So we'll keep working on it. It's basically getting the script together and getting people who are willing to act in the video,
Well,
essentially.
they seem to be very interested in that. Maybe we should shift the burden to them.
Yeah.
I mean, that's legit.
So far, that's what we've done, is let
Right,
them lead on it.
okay. So we go on now to review an adoption of the new policies. That's the new
This is tab
effect
10.
in there, yeah.
And basically, we deferred this from last time, and the revisions that you see in here attempt to just update the policies and procedures to reflect the way we currently
Right.
do business. So you'll see that we work in the commission's new statute. We talk about the fact that we'll endeavor to live stream all of our meetings, but that a decision to live stream a particular meeting is not a guarantee that all meetings will be live streamed, because we can't really do that. But Lee and I were at the Open Government Conference, and I talked to an attorney from the AG's office who said, you probably want to put a disclaimer out there, because you want to live stream as many as you can, but it's not a requirement under the act. But what you don't want to do is set an expectation among the public that everything the commission does will be live streamed no matter what. So we're trying our best to make that clear in all of our communications. I also, if you recall, some time ago, the commission had voted that the complaint screening committee would always be open to the public because there are deliberations that are inherently of interest to the public, so I made that clear in here. It's basically clarifying those types of issues. Making sure that it's in line with the statute, making sure, like we've said, that investigation panels can meet by telephone to ensure that information is gathered that's needed for deliberation, but they're not authorized to do any deliberating. And so I made that clear in here. There were some revisions to the Public Information Act. We wanted to put very clearly what the commission's policy is with respect to that, make sure people know how we accept open records requests, the fact that we may charge to provide responses within sort of the, within the bounds of what the act allows. So far, we have always provided responses to PIA requests free of charge, but if we ever got one that required significant resources, we want to make sure that we have the ability to charge for that. We also updated it because our statute now says that information filed as part of an allegation of professional negligence or misconduct that is obtained during an investigation is not subject to release under the PIA until the investigative report has come out. So we clarified that. And then we basically, there had been some pretty restrictive language in there about when commissioners can testify at legislative hearings, when they can speak to the media and so forth. And we made this a little bit less restrictive on that. Like, you don't have to get permission from the chair if somebody calls and says, we need someone from the commission to testify in 2 hours or in 3 hours, like we did to Richard once. That if Dr. DeMaio's on a plane or something, that what it used to say is unless you got permission from the chair, you couldn't testify at the hearing. And we thought that was a little bit restrictive. So we tried to just use common sense when it comes to those things. I mean, we don't want to tell a committee chairman, oh no, we can't have anybody there because our commission chair is on a flight to London and we can't get his approval, you know, because we feel like the commission works well enough that people will use good judgment. So that's it. I don't know if folks have any questions. We leave policies and procedures as a pending item always on the commission agenda. So if people go back and have thoughts that they'd like to make additional revisions or anything like that, we can always revise them subject to discussion and deliberation. It's not like this is a one-shot deal or anything.
Do we need to move to adopt the change?
That's what I was going to suggest, because it's the new, it says at on the first page, this is the new form, so I thought we should adopt it. May anyone make a motion to adopt it?
Go ahead.
I move that we adopt the changes as described by Lynn.
I'll second.
In writing.
Vote, aye. Okay, unanimous.
Okay. The next item is report from Attorney General's December Open Government Conference. Lee and I attended. It was a couple days here in Austin. There's a big open government conference and every state agency is there. And we learned a lot. They always update attendees based on what the legislative session came out with. There were quite a few things that we've talked about here, including, you know, how agencies can now have message boards online if they follow certain rules, how video conferencing works. We learned something there about how to state an attorney-client exception in an opinion request, and actually went back and amended our request based on what we learned at the conference. So it was very, very valuable. We like to always go to those every year because we are a state agency. We need to make sure we understand the PIA and the Open Meetings Act and that we're always complying with it, and that our policies and procedures reflect the law on transparency and open government. So we just wanted to let you know we went there and it was real helpful. And it was packed. People sitting on the floors, people sitting on top of each other practically.
Where was it
packed.
held? At the Capitol?
No, it was at the,
In the Arboretum.
in
too,
the Arboretum
Yeah.
area.
Uh-huh.
At
The
a
Marriott
hotel.
there, I think.
Was it a
Marriott?
Ramada? No. Renaissance,
definitely
the
one of our
Renaissance
models.
Hotel,
Austin,
Renaissance
really nice-
Austin.
Do you have anything very important to tell us about that?
No, we've already talked about it, and we update you on open government issues
Okay.
as they come up.
The important things we learned, we actually incorporated into the policies and procedures.
Okay,
The
Yeah.
main
that's good,
things.
that's good. Again, I guess you're up next for the report from the presentation.
So the Texas District and County Attorneys Association has an elected DA conference every year, and they invited the commission to present at that. I think their idea was that Richard would present, but he was in trial that week on a major case. So I went and presented along with Joshua Reese, who's the Assistant DA for Harris County, who worked on the Salvador briefing in front of the Court of Criminal Appeals. It was really great. I got to meet him in person. I've spoken with him several times, but, he and I sort of tag teamed, and we got some good questions from the group. I'm not sure. I think we were probably more relevant to larger jurisdictions than to the tiny jurisdictions, but we updated them on the hair microscopy cases. We talked about the Salvador issue. We sort of talked about what the commission does, how it might affect their lives. And it was really well received. We hope we get an invitation back next year. It also gave us an opportunity to interact with board members of TDCAA, which was great. So I think it was time very well spent, and I got the evaluations, and I think, we got a lot of excellent feedback, and so I think it was good overall. I think we'll just have to see if they invite us back next year. But it was great to have Josh Reese there, because I think there were 36 counties affected by the Salvador cases, and so it was nice that some of them were able to ask questions, or to understand where the Court of Criminal Appeals is in that decision-making process.
The other option, now that you've met them, is that they are always looking for articles for the prosecutor, which is the like bi-monthly little magazine newsletter that goes to all county and district attorneys throughout and support staff throughout the state, and they're always hungry for that. So if you had the desire to put some of this into a written form and an article form, it would reach every member of TDCA. And I think a lot of times what's important is that they have the resource available. So when they get that first call, even in a small jurisdiction, and they're asking everybody, what is the Texas Forensic Science Commission, in case they hadn't heard, that they'd have something to look to and understand the mission and reasons why it benefits them to cooperate. So just tossing that out, I mean, I'm fairly confident that if you said you'd be willing to do such an article, that they would just be wanting to know how quickly, so they'd be able to fill up that issue. But that's up to you. But
Sure,
I think that's a good step. I just think it's important that there be this interaction.
Yeah.
I'm sorry I couldn't be there for the presentation.
I think that the commission is at a stage where it's going to have to go out and talk about what it's doing and how it's interacting with the community. And that's why going to the American Academy meeting is good, because this will give you nationwide prominence and such.
Well, I think I will talk to Rob Keppel and see, or whoever it is that publishes the newsletter, and we'll get something in there.
Okay, I think that's great.
If you have ideas about what the subject should be, I could do
thought-
two. I could do one on the drug cases and one on the hair.
I think
review.
I'm envisioning the first one being just kind of an introductory kind of just an interaction, what the interaction between the commission and local county district attorney's office, and maybe having a case example where that interaction had a positive result for all members. I think, I
Okay.
view it's not as kind of a /PR informational piece.
Okay.
Yeah, and I may point out, as an editor, you're always glad to get articles. I mean, if you want to submit one, that's fine. I'm sure if you submit 3, that'll be even better.
Yeah, okay,
There's a problem
yeah.
getting decent articles.
And you'll have at least a 2-month lead time, once they agree.
All right.
You're up again.
Oh, the report from the TACLID meeting, I would say that we covered most of what was discussed yesterday. at the TACLID meeting. I'm trying to remember if there's anything that I left off. Can you all think of anything that was discussed yesterday? Oh, this is something that we'll get to later on when we add items for the next agenda. But otherwise, I think we discussed the training thoroughly, we discussed the hair review thoroughly. I can't really think of anything else, Lee. So we're in good shape there.
Okay, I think the next thing is the American Academy meeting, and with the insert, you can see what the talks are being given.
So we basically have a Texas presentation, I guess I'd call it. We have a section of the agenda in the jurisprudence section of the Academy meeting that will be all about initiatives in Texas. I don't know that they're actually calling it that, but since all of our presentations are back-to-back, I think that's...
Well, 3 are, then you
Or
have
3
a
are.
4th one is separate.
Yeah,
right?
one's separate, but 3 of them are back-to-back. So you have Chris Keneally presenting on the arson review. Then we have presentations on certification of forensic examiners and a general presentation on the Texas Forensic Science Commission as a model. And that's the presentation that I'll do with Senator Hinojosa, and he's going to the Academy meeting, which will be great exposure for the legislature, too, for the next
Right.
session. So there are those 3, and then the issue of defendant notification will be addressed on Saturday in a separate section.
Okay, the Saturday one. You'll get good attendance
Thursday at
on the
least.
Thursday one.
Probably not as good on Saturday.
Well, it depends. If they think you give you a good talk, they'll put you out on Saturday to keep the people from leaving, but you won't see any forensic pathologists on that day, let's put it that way.
So we're going to go and do the best we can with it, and
Well, I think it'll
we'll
be
report
of
back.
interest. You know, the jurisprudence section there is is not that strong, I think, you know. And you have it would be interesting.
Yeah.
Do we
And-
have a plan for trying to develop these presentations? I know that obviously I've not been able to do much in the last month or so.
I'm going to start on the PowerPoints this week.
Okay.
Um,
Do we want to try and set up a conference call?
Yeah, we need to do that. So I'll send around a doodle for that this week. I wanted to give Dr. Kerrigan a little time to get back into the swing of things.
Well, you should have some, you can use the standard
Yeah.
one for the improving forensic sciences,
Yeah, it shouldn't
with
be
the
that
Texas
hard.
flag at the beginning.
Yeah, I mean, you can't really, yes, there will be the big Texas
You should put the
flag.
Texas flag at the beginning of every talk.
Yes, we will. We will do that.
That's my major contribution to these talks, the slide of the Texas flag. That's why I
We
keep
will-
stressing it.
We will definitely do that, and I have done that in every presentation I've given, to make it clear. But I think because they're such short presentations, it would only be a few slides anyway, probably. I think we only get 20 minutes.
At most.
15 minutes for the first, 20 minutes for the second.
Yeah, but that includes, they'd like to include some level of.
Q&A,
questions, yeah.
right.
Unless they bring them at the end. Depends on how it's
Q&A,
run.
Yeah, it depends how they run it. I wouldn't count on question time. What happens is they usually put it to the end, and then everyone runs out as soon as they have questions, then everyone will run out.
Well, I mean, in terms of, just the certification, we've gotten a lot of feedback recently
Yeah.
and to incorporate relative to the meetings that we had. That would be nice to-
I think if there are a fair number of analysts who attend that, there will be questions come up on that, at least on that particular point.
It'll be interesting because since it's in jurisprudence, I'm not sure if that's going to be
Right.
Thursday,
so many
if I
lawyers.
remember, there is a criminalist session on Thursday.
Oh, yeah.
So I think that's where you'll see a lot of.
2 criminalistic sessions.
Right, you'll see a lot of analysts more at that than in the jurisprudence, so.
Yeah, but your audience that you want to get to is the jurisprudence audience, and they'll be there
Well,
because,
and if the criminalists see certification, they're gonna run over there and see. what's
Yeah.
going on.
that's right.
It's because it's, you know, it's that,
That-
oh, they must be talking, those lawyers must be talking about some kind of conspiracy. So-
Right.
First thing we do is kill all the analysts.
Yeah, actually, if you can get them with the first, they may stay for the other two.
Yeah.
All right, so we have that coming up, and that's it for the academy meeting.
Okay, now we go to the future.
Okay, so yesterday at the TACLID meeting, it was brought up that, you remember the El Paso Police Department Crime Lab investigation? We
Right.
released a report in that matter. And one of the issues at El Paso was the use of a certain type of instrument, an ion trap instrument, Varian ion trap, I think was the name of it. And what was said about that instrument was that basically it needed to be decommissioned and they needed to bring a different instrument in to do the analysis they were doing. And one of the laboratories raised the point that really the way the report reads, not only the commission report, but the DPS audit that we did, do you remember that was part of the El Paso investigation, sort of makes it seem as if the instrument itself is a problem, not that the analysts couldn't use the instrument properly, but that the instrument itself should not be used for forensics, that it's really only appropriate for research. Other labs use that instrument and use it effectively, and so I think what they would ask for is a revision to that, or an addendum that just makes clear that the commission and DPS are not condemning the instrument itself, but rather commenting on the importance of being able to use it appropriately.
Appropriate.
Yeah, otherwise you'd get into a trial and somebody will.
Yeah, I would
quote
put
this
yeah.
and suggest that the analysis is
Yeah.
flawed because of the instrument.
Now, I will say they can't quote reports in criminal and civil cases.
I know.
Under the new legislation, our reports are not admissible, but still, that's not a reason not to address it. We should address
I
the
would-
issue for accuracy,
I would
no
address
matter
it as
what.
an addendum.
Right.
Because their other version has already gone out
Mm-hmm.
and say something to the effect that there was a misunderstanding about thing, that this equipment is satisfactory when used appropriately. The problem in this case was it was not being used appropriately.
Yeah, an elaboration of what the point is.
Yeah.
So DPS is gonna do that for their audit report between now and our next meeting, and we'll follow their lead and bring some revised language. So we need to put this on the agenda for the next meeting.
Okay.
When you say that the report cannot be referenced, but can they utilize information, say, has it ever been brought up? Or has it ever been discussed that that instrument may not be
I don't know
accurate?
that they can keep an expert from saying that they refer to it. I haven't looked at that statute lately, but that's always, there's lots of indirect ways you can refer to what the commission
Yeah,
does.
I think it needs,
So.
with that point in mind, it does need to be addressed.
So what we need is a vote to put this subject on the agenda for the next meeting.
Someone want to make
Yeah,
a
so moved.
second? Yay, universal.
In terms of other agenda items, we'll probably follow the same pattern that we always do, which is to circulate an agenda, and then if
Okay.
people have comments, you can just send them to Lee.
Okay. When will be the next meeting?
April is usually the month we do it. 4th, 11th, 18th, or 25th are the Fridays.
I don't know of anything I've got. May, I have an issue for the first 2 weeks, but the rest of it.
What
Why don't
about
you
the
do-
18th?
You want to try the 18th?
April?
Mm-hmm.
That's
Oh,
good.
it is? Okay.
Oh, okay. No.
Thanks. So 4, 11, or 25?
Unless.
11?
What?
Is 11 okay?
Can I ask a question, actually?
Let's put it down and we'll see.
I forgot to bring something up that I need to bring up.
Then let's bring it up.
The, if you remember last year in Charlotte, the National Innocence Network held a conference where they asked the commission to present. They've asked the commission to present again this year, and it's in April. So either a commissioner or I can go. It's in Portland, Oregon. Do you know what the dates are?
Yeah.
April 18th? Or was that last year?
That might have been last year, because I don't know that they would, let me see if I can find the date really quickly. So I guess the first question is, do we want to send somebody? We did last year.
Yes, I think we have to send somebody.
What is the presentation that's made?
So this particular one focuses on,
It's 11th through 12, April 11th and 12th.
this is,
Well, that gets rid of the 11th.
so here's the abstract for it. In July 2013, the Federal Bureau of Investigation announced a review of thousands of microscopic hair comparison cases in which FBI agents provided invalid testimony or reporting. Joined by the Innocence Project and NACDIL, this unprecedented collaboration embarked on what may be the largest scale review of forensic evidence to date. Since the announcement has become clear, the FBI trained hair examiners may also have provided similar testimony in cases that wouldn't be covered by the FBI review, and state-level stakeholders are working to mount their own microscopic hair testimony case reviews. This session will include stakeholders participating in commission-led and network project-initiated efforts, and each will describe the challenges and opportunities afforded by their approach. So it will be a panel.
Yeah.
Then I
From
would think
different
that we'd benefit, or they would benefit, but so would we by attending that.
Yeah.
And it's in Portland. That'd be fun.
Yeah, that's not a negative.
So who would like, should we ask members of the panel if they want to go? And if nobody wants to go, then I'll go? Do you want to do it that way? Or how do you want to do it?
You're gonna have the most.
You know,
You have the most working knowledge of how
that's it.
how it's all being approached unless
Yeah.
you just can't.
I don't like to dump on you, but it turns out that you know the most. I mean, like, it's still an ongoing thing. It's changing from day to day. You know, like the number of cases that I asked you.
Okay.
Well, the background of what led
Was there
to
a
it,
problem?
and then what we're doing
No,
here.
no, there's no problem. I just don't, I want to make sure that commissioners, if they want to go, that I don't just do all the travel. I mean,
Let's
I
put
know
it
you
this
guys
way.
are
Who is-
starving to travel.
Who is the best representative in a case like this with the most knowledge?
Yeah.
That's Seal.
I would like to ask Dr. Kerrigan first if she would like to go, since she's the
Okay.
chairwoman.
Oh,
and
yeah.
If she doesn't want to go, then I'll go.
That's fine. That's fine.
So then we need probably a motion about someone.
That someone
attending
should
this.
attend them. Someone will make the motion?
Yeah, I'll make the motion.
Second? Aye? It's unanimous.
Okay, so we're down to what about the 4th for our meeting?
We're 4th or 25th, we only got 2 options.
25th is going to be a problem for me,
Okay.
because I'm out of town the entire next week for training.
Okay, so let's say the 4th.
I think 4th will work.
Is that okay?
Fine.
At this point, it looks all right.
Okay, we'll send that around for everybody.
I think we'll have more than 5.
Yeah, hopefully we'll have
have new
new
members.
members by then.
I know. It was supposed to be the last meeting. We're
Yeah.
supposed to have new members, as this has been going a while. Where will we be having the meeting?
Well, we'll have to see if they have the space available here. We'll do that
Yeah,
first
okay.
thing.
Is here okay for everyone?
Yes, it's very nice.
Yeah.
Any other topics or anyone wants to bring up? Does anyone in the audience want to speak? Yes.
Hi, Devin Potts from Innocence Project. Would be great that you're coming to the Innocence Project conference. And so the agenda is not set yet, so it'll be either Friday or Saturday. So I don't know if you want to maybe have the commission meeting on the 11th. I don't know if that's an option, although you said it might be the 4th. And the second thing is, I was at the roundtable conference in July, and I read the white papers, and they were very good, and it was very reflective of all the opinions expressed at the roundtable conference. And you did a good job of kind of bringing all the stakeholders' ideas into one cohesive report. So we're very happy with the result of those papers. All right, thanks.
Thank you.
So Did you say the 4th is a conflict with that?
Oh, no, I'm
Oh,
saying.
He was
I was
saying the 11th was an option.
Yeah, so
Probably.
Might be an
the
option.
agenda is not set yet for the
Okay, thank
Innocence Project Conference, so I was just throwing it out there.
I think the only challenge would be that then I'd have to find a flight that
Yeah.
could get me there
Yeah.
for Saturday.
Yeah.
So if we can
That's
stay
avoidable.
away from it, yeah, we should.
Yeah, I was just offering.
If we get desperate, then maybe we'll do it.
Once the Innocence Project Conference agenda is set, I'll talk to Lynn.
Is that it? Move to adjourn?
Okay. We'll adjourn.